32. So since till when he is in the duty of
Lordship, on next week.
next week. I mean, for next week,
Yes.
Are you on interim?
Yes,
Interim.
Lordship.
Interim.
Then next week, 24. He'll get it.
Wait, please, Your Lordship. Lordship, I beg to mention item number 29 of the daily list. Case diary is not available.
Pradip, the case 29 case diary Pradip Kumar Das. CD received, CD available.
CD available.
Lordship, senior is out of station. Can it be next week?
Yes.
24/5.
Yes.
Lordship, 24 senior won't be there. Can it be before that or after that? Lordship, interim is there. Yes, Lordship. Obliged, Your Lordship.
May I please Your Lordship, I beg to mention item number 7 and 8 came upon on Monday.
You are for the petition.
Yes.
After 1 week will come.
Thanks, problems.
May I please, Your Lordship? The case is charge sheeted. Yeah, during trial, petitioner has been could not appear before the trial court due to his illness, and on that day, NBW issued against the petitioner on the strength of
How many days? How many days?
85 days. 85 days today.
85 days behind the bar.
Behind the bar.
Where is the order when he was sent? When he was sent for judicial custody.
Page 19 initially granted bail. Page 19. 19.
Initially he was on bail.
Bail, yes, ma'am. Page 19. Thereafter, on subsequent dates, because of his non-appearance, bailable warrant issued. Thereafter,
Custodial order, page number 23. Page number 23.
Since 4/10/2020, NBW very.
yes.
I may be given a chance. I will regular appear before the trial.
It's 28th of February 20. February most probably he is in custody. Then
Yes.
in page number 24 it depends.
Yes, 22. Yes, on 22 he was arrested. On that day he appeared. On the strength of NBW he was arrested and thereafter produced before the court on 22. 20.
20. As well,
Yes, madam.
he can be.
Yes.
Your Mr. Your good name?
S.Y. Ahmed.
He defaulted, but he could not appear for the court. is and he was arrested on strength on 20/0/2004. Since then, considering very pending report, the Court of Session Judge Emaji.
Jamaji. Highly up.
My lord, item 2 matter may be timely.
May it please your lordship. My lord, this is a 439 application, my lord. Lordship will find the FIR at page 11. My lord. Page 11 is the FIR, my lord.
Yes.
Look, the offences are 354, 354A, 376 and 376C, my lord. From the perusal of the FIR itself, it is my lord, apparent that my lord, victim in the instant case was a consenting party, my lord. And she was major, and her age, lordship will find at page 13, my lord. That victim is 21 years on the alleged date of occurrence. She was found in her room with this accused person, my lord. And accordingly, my lord, possibly because of the brother came, informant came, my lord, possibly, my lord, this affair was lost, my lord. And her consent, my lord, lordship will again turn to page 14, my lord, because she was a consenting party, my lord, possibly due to her, my lord, soft corner against the accused person, my lord. While recording her statement under section 164, she named another character to be involved in the alleged offence. That lordship will find at paragraph 3, my lord. After going to the CD, my lord.
Azizul.
Well, I am Azizul, my lord. In her 164, she named my brother to be involved in the alleged incident. Possibly because of that relationship between the accused and the victim, my lord. And I am in
Another person, I think.
Later part, your lordship may kindly they clarified that the accused Azizul Haq was actually involved. That is the report of the IO, but at that point of time, in her
No, she after the name of Amit wrote
My
instead of Azizul.
Azizul, yes.
my lord.
No, but it was as per the report of the IO, it was a slip of tongue.
Tongue, my lord. Possibly that cannot. And I am in detention for 65 days, my lord. Whether my detention is necessary, my lord.
yes, ma'am.
I am NZ, my lord.
That and love and the effect can be more day was 21 and further deep since when he is in custody 11/4
11-3, my lord.
11
3, my lord. Forwarding report page 12, my lord. Top right hand corner button.
FIR which was shown before the in page 11, it's seen that 11.4
No, my lord. FIR was possibly seen by the lad and based after 1 month, my lord.
after 1 month we cannot get
Maybe, my lord. But it was registered on 10-3, my lord, down below, my lord.
so where
CGM Pokraja, my lord.
did you focus?
My lord. I am obliged. Deeply obliged.
May I please? This is 439 application. FIR is on page 10. Allegation against me, I am the receiver of the stolen property. Already recovered from the me. Forwarding is page 17. Ground of arrest, only the CDR analysis of Asif shows his regular contact with me. And the stolen property already recovered. Suspected ground, I have been arrested. And I have behind the word more than 37 days behind the word. Whether my detention is required, already recovered item from me. Stolen property. I was not at the place of occurrence and I was not there. Manufacturer court has been arrested on particular date of offense. Whether my detention is 37 behind the word.
430 there.
Yes. Only CDR's analysis of Asif shows his regular contact with me because I am the courier service. I have the courier service, so I have regular contact with all the customers.
You receive all the stolen property.
My lord,
He had a problem.
that is why, my lord, this stealing took place, my lord, because they know that there is a person to whom we can say
Purchase all.
he purchased only. That is why this is going on.
37 days behind. 30.
For a short.
Lord,
Give a short period.
Yes.
That's it.
Lord,
Okay.
And let's next week.
Much.
May I please, Your Lordship. Lordship, 439 application. As of today, 9 days behind the bar, Lordship. Lordship, FIR is on page 9, Lordship.
390 is there.
392 is there.
Case diary may be called for.
All dedicated. All
29.
dedicated.
29.
No, let it be in the my lord, June, my lord, because the FIR is of 3-5, my lord. At least some investigation is
Odd. Okay.
on the
Can it be on the 1st of June, 3rd of June, Lordship? 3rd of June.
Okay. Third. Okay.
Obliged.
May I please, Your Lordship? Lordship, 439 application, case registered under section 376 and 506. FIR Lordship will find in page number 11. He is behind the bar for 38 days. This is the FIR in page number 11, Lordship. May I read it out, Lordship? সন্মানপূৰ্বক বিনিময় নিবেদন এই যে তলত উল্লেখ কৰা আসামীজনে এজাহাৰকাৰীক ভাল পোৱাৰ বিয়া কৰাৰ প্ৰতিশ্ৰুতি দি আজি প্ৰায় 1 বছৰৰ পৰা আসামীজনৰ ঘৰত মাতি আনি তাইৰ ইচ্ছাৰ বিৰুদ্ধে ধৰ্ষণ কৰি থাকে। এজাহাৰকাৰীয়ে উক্ত কামত বাধা প্ৰদান কৰি তাক হত্যা কৰাৰ ভাবুকি দিয়ে। এতিয়া আসামীজনে অন্য এজনী ছোৱালী বিয়া পাতি সংসাৰ কৰি আছে। This is the allegation, Lordship. This is totally false allegation, Lordship. He has not been committing any alleged offense for the last 1 year. And some cordial relationship were developed between them. And now, Lordship, he is not marrying anybody. But
Not married with another girl.
no, not marrying, Lordship. This is totally false, Lordship. The informant is putting pressure on him to marry her. So he refused. That is why he has lost this case, Lordship. Now 38 days behind the bar.
Yes, sir.
164 statement
Is there.
not there, my lord. Required.
Most probably 1 year it was continuing.
Yes, man. That part is there. Fire they are in love, my lord.
Mr. KK
And
and Mr. KK. Not part. Okay, right. But now and both those yeah, right. No, also, but it, that, it's not, that, it is for, wait, what, that, oh, oh, but, it, but I find it part of what I would what where it is spent
CGM Gwalpara.
CPM Golfer.
Gwalpara.
One time my submission date is 376, my lord. So I have prayed for the city. My submission.
You have prayed for kitchen and once before prayer the defense. I have already checked.
Yes.
Development.
May I please put 39 application, my lord. FIR is on page 9, my lord. Today is 41 days behind the bar, my lord. And military is 60 days, my lord.
Case of 70
370, my lord.
Trafficking.
trafficking.
And already recovered is
Traffic, my lord.
The case of trafficking.
Trafficking.
CD to call.
City will required.
Yes, he is in custody since last
41 days, my lord.
41 days. So we tried.
Yes. 29.
28 to the end. 28 to
28.
oh, like.
Please. Actually, by this revision petition, the petitioner praying for the Jimma of his vehicle which has been seized on 7/3/24. Today is the 70 days, Lordship. And in connection with Mahagor PS case number 2424. FIR is page number 21, Lordship. What happened in this case, Lordship? One Hafizur Rahman has lodged an FIR stating that his vehicle number is AS01FC7935, that is stolen by some unknown miscreants. And accordingly, the Bhangar police has arrested 4 accused persons. Out of the 4 accused persons, 1 accused is my husband of the petitioner. That stolen vehicle has been recovered, Lordship. And at the time of arrest of my husband, my vehicle also will seized. And my vehicle number is, Lordship, A04K2926. And it is lying in the police station since last 70 days, Lordship. The seizure list is...
Have you filed any petition reporting?
Yes, Lordship. That is in impugned order in page number 29, Lordship.
The second paragraph, my lord.
Yes. That's what I am.
Yes.
Because the vehicle was used.
Yes, used, and my lord, it is stated that she did not appear before the PS along with the valid document, and during investigation it appears that vehicle was used in many types of crimes in Northeast India, my lord, in several crimes. And another thing, my lord, in the next line, my lord, your lordship will find petitioner is directed to appear before the IO, my lord, whether he has appeared or
Yes,
not.
I appeared before the IO 3 times, Lordship, but with all the relevant, all the documents. I have the original, all the documents, but no Jimma is allowed to me. That's why
Report be called,
70 days, Lordship.
whether he has produced any document or not.
Call for the
Lordship.
also.
Lordship.
And if she already appeared the book and the original documents are able to record also, right?
Yes, Lordship, on record.
Submit.
Yeah, I have submitted.
So that simple
Report may be called.
I guess the
Do not ask me.
Hello.
May it please, my lord. This petition I have filed, my lord, for quashing of an CR case, complaint case number 1 of 2024 before, pending before the Judicial Magistrate First Class Dibrugarh, my lord. I am challenging this particular case, my lord, mainly on three folds, my lord. Firstly, that the dispute in hand is entirely a civil dispute, my lord. Secondly, this is a second case that has been preferred, my lord. Initially, one FIR was lodged, my lord, completely on different facts, my lord. Thirdly, my lord, and this is a second case, my lord. Thirdly, on the fact that there has been improvement in the case, my lord, so as to attract a specific section, my lord, from the first FIR, my lord. Improvement from the first FIR, my lord. First FIR was lodged on a different context, my lord. Facts were completely different. The matter have been improved, my lord. The statements have been, certain statements have been brought in, my lord. And second FIR has been lodged, my lord. This particular complaint case has been lodged. May I please take my lord to the complaint first, my lord? Page number 23, my lord. My lord, the complaint is the respondent number 2, my lord. Accused person number 1, my lord. Kamleshwar Panging, my lord. That the complaint is a permanent resident of Dibrugarh, my lord. Second paragraph, the accused person number is a permanent resident of Dibrugarh, and the accused person number 2 is also a resident of Dibrugarh. The accused person number 2 entered into an agreement for sale with the complainant on 15/9/2023 to sell a property of land measuring 2 kotha 10 losa out of total land measuring 5 biga 6 losa covered by DAG number so and so, situated at Dibrugarh, to the complainant at a total consideration of 1,25,000. That as per the said agreement for sale, the complainant paid 50,000 only as advance payment out of the total purchase consideration of 1,25,000 only to the accused person number 2, and the remaining balance consideration of 75,000 only shall be paid by the complainant on the date of registration of the sale deed. That on receipt of the advance payment of 50,000 only to the accused person number 2, the accused person number 2 has delivered the physical possession of this aforesaid land to the complainant with the right or authority to make any construction, that is boundary wall or bamboo fencing, that is etc. on the aforesaid land. That on acquiring physical possession of the land and in compliance to the terms and condition of the said agreement for sale, when the complainant visited the said land on 3/12/2023 with labor, bamboo fencing, cement, sand, gitti, cement post, etc., with the intention to construct a boundary fencing over the said plot of land, the accused person number 1 started arguing with the complainant and obstructed and threatened the complainant with dao and attempted to kill the complainant and forced the complainant to leave the place with the labor and material brought for the purpose of construction of boundary fencing over the said land. So this is the only allegation against me in the entire my lord complaint case. Secondly, my lord, paragraph number 8, my lord.
Case was under 506, 34 and 507.
My lord, cognizance only has been taken under 506, my lord. Order is at page number 30.
Against both the accused persons.
My lord?
Against both the accused persons.
Against both the accused persons.
33.
Page number 30, my lord. Now, my lord, paragraph number 8, my lord, of the complaint. That the complaint has lodged an FIR before the officer in charge, Lepetkota Police Station, Lepetkota District, Dibrugarh, Assam on 3/12/2023 against the accused person number 1 and 2 in respect of not allowing obstructing the complaint in constructing boundary fencing over the same. So on the date of incident, my lord, he has lodged this particular FIR, my lord, on the same day. And the cause of action of this particular case is also on the same day, my lord. Now, if I may take my lord to the FIR, my lord, for a minute. Page number 32, my lord. Here the incident is completely different, my lord. May I, my lord? Most respectfully submitted that as per the agreement for sale dated 25/9/2023, C. Anwar Khan, son of Sri late Ali Shah Khan, resident of Dibrugarh, took 50,000 as advance out of the total consideration of 1,25,000 from Rupanjali Mili, that is the complainant, for the purpose of buying a plot of land measuring 2 kotha Dohlosa covered by Dag number so-and-so under revenue village of so-and-so, Dibrugarh revenue circle. On 3/12/2023, when I went to demarcate Sri Kamleshwar Panging village so-and-so, post office so-and-so, obstructed me from doing so. On communicating with the owner of the land, Anwar Khan, he misbehaved with me. It is only as regard to that I have obstructed this particular person from building the. But as no stringent action was taken against me, this particular complaint has come up with the complaint and has added that I have chased them with a dao, my lord. Completely change in facts, my lord.
Any comments?
Seems to be, my lord, civil case, my lord, civil dispute. That the respondent is there, my lord. For this people.
Other civil dispute but against him.
Criminal. 307 is there.
307.
Yes.
As per this.
As per this.
So this is 307.
Yes.
Cognizance was
Not taken. To my belief, the investigation is going on in the FIR, my lord. I do not have any information up to that regard. Information is already on the same date, same incident, my lord. She has already lodged an FIR. Certainly, if required, appropriate provisions of the IPC will be, my lord, framed or charge sheet will be filed.
for Mr. G.
Arson, sorry.
Have any different player?
My lord, first day of the, my lord, complaint. I am a senior citizen, my lord.
But the agreement was from Rupanjali Pangi husband, with husband or with her?
My lord, from her, with my lord, the original, the respond number 2, my lord.
No. Anwar Khan.
Anwar Khan is the original owner, my lord. Deeply obliged.
Yes, Your Lordship. May I please, Your Lordship, the application under section 4838, Your Lordship. And the FIR is at page 8, Your Lordship, the typed copy, Your Lordship. May I read the FIR, Your Lordship? With due respect, it is to inform you that on 26/3/24 at about 7:45 p.m., my driver, Sheikh Sandeep Das, took my vehicle, bus, bearing registration number so and so, and parked the vehicle at the parking slot of Mahamrityunjay Mandir, and he was taking rest at driver's seat. At that time, the petitioner, son of so and so, village so and so, boarded the path with an intention to cause death and assaulted the driver with sharp weapon on his head and backside, causing injury. Immediately, said Sandeep Das became senseless, and the people present there raised hue and cry. And because of that, the accused left the place. The victim was then shifted to the civil hospital by the bus stop, and presently he is undergoing treatment. This is the FIR, Your Lordship. Your Lordship, my submission is at page 6, Your Lordship, wherein the driver Sandeep Das has passed some poor comments against the wife of the petitioner, and there was some tussle between them, Your Lordship, but no such sharp weapon was used during that argument, Your Lordship, and this FIR is not and there was no injury, Your Lordship.
There may be a simple scuffle between the parties, but the question is that is not only registered under
37, 26 and 307 is the, Your Lordship.
We have
Yes, Jimma. 46.
A short date may be given, Your Lordship, 46.
48.
short date,
On 24, 25, Your Lordship.
is not possible. 31.
Deeply obliged.
May I please, Lordship? 438 bail application, Lordship. FIR at page 13. As stated version of that. The allegation is that, Lordship, that the grandfather of the informant was the absolute owner of a plot of land measuring 2 kathas 16 lesser covered by dark number 751 and KT Patta 31A of Revenue Village, Koromutolia. And he has stated that on 18/3/2024, some person has informed him that the accused person, along with some other person, has started gather some construction material over his plot of land. And when he is inquired, he came to know that they are the owner of the. They claim that the grandfather of the informant had sold over the entire plot of land in favor of them. And on the basis of the said FIR, Lordship, the case was registered under section 409, 420, 468 and 471 of IPC. Lordship, kindly look into the page number 20. It is a registered sale deed executed by the grandfather of the informant. It was executed in the year of 2007, Lordship. And on the basis of the said sale deed, the petitioner comes to into the possession of the land, and he has mutated his name in respect of the land revenue records, and he is regularly paying the revenue in respect of the state land. And we have annexed the land revenue receipt at page number 26, Lordship. The informant has said over.
It is also registered under 468 and 471.
Lordship. The informant has said over for more than 17 years, and suddenly he has come and claimed that his grandfather has not executed any sale deed in favor of the informant.
But grandfather is still alive or he no?
No, he is already died. Lord. Grandfather is died, and his father is also died. But interestingly, he has not mutated his name in respect of the land revenue record, and he has admitted in his affair also.
CDB there, my lord, these types of cases are coming out. But the investigation has to say, my lord, sorry.
Otherwise, maybe just
Yes, in other words,
but
my lord,
the
if
question is that the court signature, obtaining of court signature, court
that
the
part,
allegations with the company of no, with the connivance with the office space, the office. So
Yes.
let us call for the case.
Earlier, my lord.
Otherwise, your there it was sale was
whether thing the signatures could be verified or not, my lord. If signatures are verified, my lord.
If lordship, any sort date may be possible.
It's not possible, I think. Third, huh? 3rd of June. I think that may not be possible. 3rd of June.
Earlier, my lordship.
For 30th application, my lord, this place of occurrence of the is the petitioner's residence as 9. My lord, 2 cross case is in file. And page 11 is this informant has filed this case that his son Sumanto Sil, who was invited inside the house of this petitioner at 9 in order to murder him, and then he sustained injury, he escaped. And page 70 is the FIR filed by the Dipti Das, who says that at 9:30 the Sumanto appeared their residence and has some sexual intercourse, and husband appeared, he fled away and sustained injury. My lord, this is the 2 FIR, my lord. My lord, page 11 is the FIR, this in the bail petition person file. Admittedly, this place of occurrence is the residence of the petitioner, and 9:30. And they added some allegation not possible, my lord. 1,50,000, how can carry an election code of conduct is that? And mobile is left, my lord, when it's fled away, to let this mobile in.
So as per you, what kind of
7.
he is asking?
Yes, 17.
No, because it that as per allegation there was an
Yes.
by he was trying to strangulate him,
Yes.
and other one is with the record and all, is with the
Yes.
stabbed her.
Yes.
So that's why possibility.
Yes, 326 and this. But place 17, that affair will kindly see why he came there, my lord. Place page 17 is the Dipti Das, this petition number 2, wife. She lost.
Yes, both the city, and because my, it is stated that my lord, presently the boy is under unconscious state, and whether that is true or not, my lord, whether he is alive or not, my lord, that is.
But the dagger is recovered or not, that is many things is there. But thing is this place of occurrence is there, and 1,50,000 is impossible. How can he carry the election code of conduct in 25/4? It is in there. So I
Where
think
1,50,000 is?
yes, my lord.
Where it is?
In page 12, my
Page
lord,
12.
the later part of the environment.
So
So
draw
Page
some
12.
mens rea, my lord, they have mentioned everything. But thing is that something happened there at residence.
My lord,
At
from
night.
middleman, I reading, my lord. At present, the state boy is under treatment. At present, the state boy cannot speak, and he is in unconscious state. In addition to that, the accused snatched a mobile and a sum of rupees 1,50,000.
And he left the mobile and his sandal means shoes there. It is in page 17. It is mentioned.
1,50,000 maybe an
Exaggerated. And mobile handset he admitted when he fled.
But he is unconscious.
Yes, how he sustained injury, my lord. That is the matter of investigation, my lord. At this stage, he is a banana seller, and his wife is under some, my lord, is for defense or something. They have done something, my lord. But place of occurrence is their house at night, my lord, unauthorized. So, considering that, sir, interim may be considered, my lord, he is banana seller.
Somehow, because the incident has happened in the month of April, till now he is selling bananas.
No, banana is
okay,
left. So there is some difficulty, my lord.
29th, we are trying to give a shortage. Then about don't have any date. 29th, we are giving full CDP call.
Obliged.
The petitioner before Lordship, my lord, are vegetable vendors of Mongol town, my lord, of ward number 3, my lord. Whatever on the date of occurrence, actually, his informant son and his husband, they are selling pan, my lord, on that point, and they blocked the road, my lord. As a result, altercation took place, my lord, between some of the vendors. As a result, there was a few fight between them, my lord, and somebody got injured. Now the FIR was lodged by the wife of the injured person, my lord, that you will also find at page 8, my lord, annexure 1, my lord. It states that on 24/4/2024, in the morning around 9:15 p.m., my husband Jiten Deka and my son came to Mongolia telemarket to sell battle leaf. Around 10-15 persons restrained them from selling well, threatened them not to come to in the near future to the market. The victim raised objection. The accused persons attacked them with dao, dagger, wooden button, bamboo stick in order to kill them and severely assault them and kicked up pan and threw it to the drain. As a result, my husband received grievous injury in his right leg, right hand and head. They also attacked my son in order to kill him. So he has been seriously injured. As a result, fell down. Now, therefore, accused persons also assaulted the victim, which slapped him with fists and blows. Because of the crowd, they gathered there. My husband and son were saved from the hands of the accused person. At present, injuries sustained by them are grievous severe. But nobody has been named in the FIR. However, during the course of investigation, my lord, the male culprit was taken into custody. Your lordship will find at page annexure 2, page 13, my lord. It's the forwarding report. There, your lordship, the name of this person is Imdadul Haq, my lord. And the grounds of arrest stated that accused person is found involved in the commission of crime which they have been arrested and produced before the court. The accused person is identified by witnesses, which he has been arrested and forwarded to the honorable court. The sufficient evidence is found against the arrested accused person from the eyewitnesses. Accused person arrested to prevent from committing further offences. Arrested is released on bail, he will temper. So now we, the petitioners, do not name my, now police is harassing me. They are not allowing us to sit. They are asking us to visit the police station. So we apprehend that at any moment of time, we may apprehend that man. Because now it has come in investigation, he is the male culprit, man.
Who is the male culprit?
The arrested accused person, man. Because there is in the forwarding report, it was stated that witnesses identified, that it doesn't say that other persons also involved in the forwarding report. It is categorical that statement of the investigating officers that this arrested accused person was identified and he is involved in the incident.
Mentioned in the FIR that only one accused come or one person come.
But it was a free fight actually. But it was, they have made it actually. She is not an eyewitness actually. Later on, she has lost the FIR.
No,
yes, well, yeah.
It's not that he was a single.
Understand, well, but in the forwarding report, they could have at least said that there are others also involved. His personal detention is necessary or police custody is necessary to unearth who are the culprits. Because witnesses just said that this is the person who is responsible. Nowhere others were named or identified or something else. So, but even then, police is harassing us. That's why before your lordship.
Yes.
Yes, madam. It is stated, madam, that he was identified by the one eyewitness, madam. But whether regarding others, madam, it is silent. But we have to be sure from the, because the FIR says there are 15 persons, madam. He alone could not have been made such an injury, madam, because injuries are also serious as per FIR. my lord, his son and husband both are assaulted, my lord. So one person cannot be from the circumstances. Yes.
Intent may be considered by.
Consider finally only.
Yes. First week of date.
First week of June.
First week of June, man.
No.
3 or 4?
Yes.
3 or
3rd June or 4th?
Third.
3rd June.
Intent may be considered by. Because they are petty vendors, my lord. They cannot.
Allegation is that not only the husband but their son also
I understand, my lord, but had it been a case, my lord, because she is not eyewitness. She came later on, man. And your lordship may kindly see, she typed the FIR in the court, man. So there is manipulation, man, subsequently.
But the FIR says that there are 10-15 numbers of
I understand, my lord, but since the forwarding report,
we will call for the case diary, let us see on it.
No.
According to us, the injuries are not so serious, my lord, not grievous, simple. Or can it be on past in maybe Saturday, 3rd, man, yes.
May it please your lordship. 438 application, my lord. Before I take your lordship to the FIR against which I have come before this honorable court, my lord, may I take your lordship's attention to the FIR, my lord, which I have filed much prior to the filing of this particular case. My lordship will find at page 39 that I have filed, my lord. Dated 24/4/2024. Page 39. May I read, my lord? With due respect, this is to inform you that I was entrusted with work order from the Forest Department, namely so-and-so, so-and-so, so-and-so. The said work is my first work with the Forest Department. While executing this said work, I faced certain difficulties like theft and damage of construction of work. Accordingly, Deed and Range Officer of Abhoypur Forest Range Office asked me to take help of one Sri Pradip Gogoi, who hold good experience in such kind of work of the Forest Department. Accordingly, on a verbal agreement, both of us started executing the work order received by me for completion. During the pendency of the said work, as I have spent considerable amount of money and the said Partha Gogoi is also invested some money, so we decided to raise a running bill. As Sri Partha Gogoi is already experienced in such kind of work in raising bills, so he took the responsibility regarding raising of bills, etc. Accordingly, the bills were raised before the Office of Divisional Forest Officer Shivsagar by Sri Partha Gogoi. Pursuant to raising of bills by Sri Partha Gogoi before the DFO, he collected the forwarded copy of the running bill signed by the DFO and came to Guwahati to submit the same before Aranya Bhavan. Thereafter, upon such submission of documents, the officials of Aranya Bhavan directed Sri Partha Gogoi to obtain a signature of the earlier DFO of Shivsagar, who submitted a report regarding the progress of work order. Accordingly, Sri Partha Gogoi informed me telephonically about the progress of the same and assured me that he would get the signatures done. Thereafter, Sri Partha Gogoi again contacted and informed me that he obtained the signatures of the earlier DFO, now retired, in the running bill and sent a copy to me over WhatsApp. Upon seeing the signatures, I got suspicious as the signatures does not seem to match the signatures of earlier DFO, and immediately I instructed Sri Partha Gogoi not to submit the same, to which he replied in affirmative. On 23/4/2024 at around 6:14 p.m., I was informed telephonically by Sri Partha Gogoi that someone had forged the signature of a retired government official in connection with the bills submitted and received by Aranya Bhavan, Panjabari Road, Patagoli, Guwahati, Assam, in relation to work order issued to me. This is important, my lord. The telephonic conversation was recorded and is saved in my phone, where Sri Partha Gogoi admitted that said action was solely done by him through some brokers in spite of my repeated resistance. Then, my lord, the FIR which was filed against me, that my lordship will find at page 39. Some copy to the original copy I am placing, my lord.
Not 39.
Certain
39 is your
39 is the FIR against which I have come before this honorable court, my lord.
This is the FIR.
39 is the FIR, my lord, which is, my lord, against which I have come before this honorable court. The earlier one, my lord, dated 6/5/2024, my lord, 24/4/2024 that I filed, my lord. Now this is the FIR 6/5/2024.
You file.
24/4/24 I filed, my lord. This FIR is of 6/5/2024, subsequent to the FIR filed by me, my lord. For a moment, page 16. Oh, it was 6/4. Page 16, my lord. This FIR has been filed against me, my lord. Information received date, my lordship may kindly see. 6/5/2024, my lord. Now, my lord, contents, my lordship will find at page 18. May I read, my lord? Page 18.
Just saying that the FIR was on 16/4.
16/4, it is, that letter was issued most probably, my lord. But page 19, my lordship may kindly see. Received the FIR and registered Sonari PS case number so and so, so and so, so and so. I shall investigate the case. Then, my lord, down below, my lord, 6/5/2024. My lord. Page 18 is the FIR which is against me, my lord. The relevant part is 4th para, my lord. On 23/2024, it was learned from the APCC CEO CMPA Aranya Bhavan Guwahati that Sri Bornil Bora Gohai has submitted his bills which were duly countersigned by deed and DFO and is under process at his office at Aranya Bhavan Guwahati. The matter of getting it countersigned from the DFO was doubtful, and on enquiry it was learned that DFO never put up his signature on any bills of Bornil Bora Gohai. This incident confirmed that he has forged the signature, my lord. This is the allegation against me, my lord. Now is the situation, my lord. This FIR has been filed against me. Prior to filing of this FIR, my lord, much prior to that, my lord, I have already informed, my lord, the dispute police station about the commission of an offence, my lord. If, my lord, under these circumstances, my lord, this particular aspect is not placed before the investigating officer of the Sonari police station, the actual truth, my lord, will never come up, my lord, and an innocent person will suffer, my lord. And I have the entire recording, my lord, wherein, my lord, it is, if my lordship may permit me, I can play it, my lord, here, the conversation, my lord.
Lost by whom?
The first FIR lost by me, my lord.
You and
Second FIR lost by DFO, my lord.
The DFO.
My lordship. And regarding the first FIR, my lord, the investigating officer of the Sonari police station is unaware of, my lord. And that truth will never come up if I am not allowed to appear and, my lord, record my statement and place all this factual aspect before the IO, my lord. And the innocent person will suffer, my lord. So I pray, my lord, I may be allowed some protection, my lord, and I'll appear before the IO, my lord, and I'll place the entire, my lord, the factual position of this case, my lord. That is my limited prayer at this stage, my lord. So that, my lord, the truth may be, my lord, it comes out, my lord, and investigation heads in a proper direction, my lord.
My lord, as part of, my lord, FIR, it is in 16/4 it is reported, and the bills were, my lord, submitted on, my lord, 19/12. It is in the month of December, my lord. 19/12, my lord, on field verification. Before that, my lord, because FIR stated that, my lord, on completion of the work, my lord, bills were submitted, and thereafter, my lord, yes, thereafter, my lord, field verification report was 19/12, my lord. When the bills were raised, my lord, thereafter enquiry was conducted, and the field verification report suggests that the work is not completed, half completed. So thereafter, my lord, enquiry has been done, and regarding how the bills came, my lord. The bills came because of the signatures of DFO, my lord. Thereafter, enquiry has been done, and it has been found that DFO's signature is, my lord, forged, my lord. So the bills were actually submitted by them, my lord.
So it is
accused, my lord. So there's some doubt is there, that is one.
So, my lord, that is what my case is, my lord. It is not a case in the FIR, my lord, in present case, that the amount which is raised in the bill is incorrect. Everything is correct, only the signature of the DFO is under question, my lord. And regarding that aspect, registration of this particular case, much prior to that, I have already informed the dispute police station about commission of this particular case, my lord. So the investigating officer, my lord, has to know about the actual position, my lord. That limited prayer I am making, my lord.
Partho, whose name is as per one Partho.
Partho Gogoi, my lord.
He collected the signature of 12
Yes,
of PFO as per their case.
Yes, madam.
They said one Partho
Gogoi.
Partho, he collected the
Yes,
signature.
but we are not. Yes, madam. But
My
the
lord.
case is, madam. The case is that, madam.
Case has been filed against me,
the
my
work
lord.
order is issued against his petitioner, madam. So, madam, this when Partho
I
came,
have-
that is his person, madam. We don't know who is Partho.
I have annexed the bills also, my lord. In the bills submitted.
In our picture, it is
Not petitioner, madam. It is.
But from his.
Yes, madam. Who is that Partho, madam? We don't know, madam, now. Yes. Who is that Partho, madam? We don't know now, madam.
That is why, my lord,
who is that Partho, madam?
to unravel the truth, my lord,
fact is
that has
my
to
lord,
come, my lord.
They were entrusted with the work order and they have submitted the bills, madam. That is what the case is.
If my lordship permits me, may I, for a moment, my lord, only little conversation may I place, my lord. The conversation which I have specific, my lordship. My prayer is I want to place all this factual position before the investigating officer so that, my lord, the investigation proceeds in a correct direction and an innocent person is, my lord, may not suffer, my lord. That is my limited prayer, my lord, at this stage, my lord. M.K. Das.
That privately had notified before.
Dispur police station.
In particularly fraud picture of before. But also much private for the file that on 24 also registered as it is registered.
That knowledge I don't have, my lord, but page 40 they have received, my lord. Page 40 is the seal and signature, my lord. Page 40, my lord.
Where is the other page? You have not filed the whether it's registered or not.
Page 40 is the, my lord, received copy, my lord, that I have to confirm, my lord.
But it's not written. But it's not written. That the acquired the further submit the acquired note by him. It is about and it was in fact one part of
Gogoi.
and about it part and it some broker of five with not five but the there are five no but but for good at happy
My lord,
Which
no,
you
my
filed
lord.
on 1912?
1912, why I am saying so, my lord?
No, as per this was submitted on 1904.
No, my lord. 1912, my lord, there is a stated that on completion of the work, being part payment was submitted by contract against his on field verification by the RO on 1912. The bills were submitted before 1912. That means, my lord, if we
For party and the only court signature therefore by the for that provided with the
deeply obliged, within 7 days from today, my lord. My lord, I am highly obliged. Highly obliged. Deeply obliged.
May I please your lordship? This is a 438 application. The FIR is at page number 14, your lordship. The FIR is registered under 120B, 420, 468 and 471 and 34, your lordship. The petitioner herein is a senior sub-registrar and presently posted as Silsar, your lordship. The allegation in the FIR is that, your lordship, the informant is a owner of a land and the accused number 1 is one Anwar Hussain. In connivance with the accused number 2, that is one Paribhanu Nesa, forged documents for obtaining a sale permission for executing a sale deed in favor of the accused number 2, your lordship. Thereafter, your lordship, this FIR name persons were arrested and subsequently released on bail, your lordship. Your lordship, on similar apprehension, your lordship, the circle officer also appeared before this honorable court, and this honorable court was pleased to grant him the privilege of pre-arrest bail. Then the bail was also made absolute, your lordship. The order is at page number 27, your lordship. This was the circle officer of the concerned place, your lordship. At page number 27, your lordship. The role of your lordship knows the role of the circle officer was to verify the documents. Then it has to be sent to the district commissioner, deputy commissioner, your lordship. Then deputy commissioner issues a NOC. Thereafter, the NOC has been sent to the sub-registrar, and on the basis of the NOC, I being a sub-registrar is empowered to register any sale deed, your lordship. However, when these things came into light, initiative was already taken to cancel the sale deed, your lordship. I will appear before the investigation and cooperate, your lordship. Some interim protection may be given, your lordship.
senior sub-registrar. Or
My lord, yes, ma'am. The earlier one is a sub-registrar and the case diary has been produced before granting the bail. So, here also, my lord, I pray that my lord, CD may be called for my lord. The registrar has to, my lord, has a definite role to play, my lord, because he is the person who registered the sale deed, my lord. And in other cases, we have found, my lord, all are involved in these types of offences, my lord. We cannot deny, my lord, who is in the
Lordship, I will record my statement before the investigating officer, your lordship, because the circle officer was granted interim by your lordship. Thereafter, that is on page number 27, your lordship, and on page number 29 is the absolute, your lordship, absolute bail order, your lordship. S.A. Hussain, Your Lordship.
And one state was they put up the employee name in one. Oh no, it's not product number one. And it was at the port. Okay, 7 days to appear PIO. Open.
मतलब like
Okay.
Lord.
Well,
May I please, my lord? This is a transit bail application. I have received a 41A notice from Mizoram police, whereby I have been directed to appear before the police tomorrow at 10 a.m. in Aizawl. So I am travelling to Mizoram today from Guwahati to appear before Mizoram police tomorrow morning. I have appeared before your lordship to get protection from arrest, at least for 2 days, so that I can appear and file anticipatory bail application in Mizoram. For your lordship convenience, I have prepared a note. I would like to. My lord, the protection is very significant for me on 3 grounds. My husband is already in custody with Mizoram police for last 22 days. The arrest memo is enclosed at page number 16 of the petition. Secondly, I am the only lady who is looking after my ailing mother-in-law, aged about 64 years, and my single mother, who is also 60 years of age. My mother-in-law is suffering from various diseases. Number one is severe bilateral osteoarthritis for long time. She has been referred by the doctor for knee replacement surgery.
So as per 41A notice, you are to appear before when?
Tomorrow morning. I am traveling to Mizoram. This is the boarding pass. I am traveling today to appear tomorrow.
Yes, you are appearing. Any other subject?
I need a protection for at least 2 weeks, my lord. I would like to rely upon certain case laws, which I would like to place before your lordship. Shall I proceed, my lord? Number one is Subham Kar Chaudhary versus State of Goa. The Honorable High Court at Goa has granted transit anticipatory bail to the petitioner for 10 days, just to enable him to approach the competent court to seek appropriate relief. The FIR was registered in New Delhi and the bail was granted at Goa. The relevant page, para is 7. Shall I read, my lord?
7 is the relevant paragraph.
7. And the second judgment is Nikita Jacob versus State of Maharashtra, in which the Honorable High Court at Maharashtra has granted 3 weeks transit anticipatory bail to the petitioner to enable her to approach the competent court to seek the relief. The FIR was registered in New Delhi and the relief was granted in Maharashtra. The relevant para are 1, 12, 16 and 17. The third judgment is Priya Mukherjee versus State of Karnataka, in which the interim of 20 days was granted to the petitioner to enable her to approach the court of competent jurisdiction to file the appropriate relief. The FIR was registered in Mumbai and the relief was granted in Karnataka. The relevant para are 31, 40 and 41. And the fourth one is Priya Indoria versus State of Karnataka, in which the relief was granted by the Honorable Supreme Court of India for 4 weeks to enable the petitioner to approach the court of competent jurisdiction to seek the relief. The FIR was registered in Rajasthan and the relief was granted in Karnataka. The relevant para are 101, 103 and 106.
May plead your lordship. In this case, lordship, he is seeking bail for 2 weeks, lordship. Otherwise, he has submitted that he is going to appear tomorrow, lordship, because tomorrow is the date, lordship. In fact, lordship, in a recent judgment passed by the Honorable Supreme Court in the month of November, lordship, in what circumstances transit bail can be granted, that was given, lordship, and the ground mentioned in the judgment, those are not attract in his case, lordship. This is the judgment, lordship, paragraph 36, lordship, and I have marked, lordship. Very recent judgment, lordship. Every judgment, earlier judgment was discussed in this case, lordship. Long judgment, lordship. Last part, lordship, 36. Under what circumstances transit bail can be granted?
So here he basically brought 2-3 reasons, grounds, I think.
Husband was arrested, lordship.
Husband was arrested,
And
mother and mother-in-law are ailing, and there are no persons to look up.
Well,
These
these are the only ground, lord.
Milord, I would like to place reliance on para 103 of the same judgment which was placed by the learned counsel. Para 103 of the same judgment. 103. 103. Yeah, new one. November 1. Para 103 of this Priya Indoria. Judgment number 4. You know.
Number 103.
103. No. You have downloaded it from SEC?
No, Manupatra.
The source are different. Actually, it has been downloaded from Manupatra, and mine is SEC. Same judgment. Salary. If a rejection of the plea for a limited transitory anticipatory bail is made solely with reference to the concept of territorial jurisdiction, it would be adding a restriction to the exercise powers under force 38. Thus, in our view, would result in miscarriage and travesty of justice, aggravating the adversity of the accused who is apprehending arrest. It would also be against the principle of access to justice. We say so far for no reason that an accused is presumed to be innocent until proven guilty beyond reasonable doubt and in accordance with law. If the circumstances we hold that court of session or the high court, as the case may be, can exercise jurisdiction and entertain a plea for limited anticipatory bail even if the FIR has not been filed within the territorial jurisdiction and depending upon the facts and circumstances of the case. If the accused is apprehending arrest, makes out a case for grant of anticipatory bail, but having regard to the facts. That's all. And furthermore, C is not an FIR named accused. She has already cooperated with the investigating officer. Her house was also searched on 8th of this month. She had given all the document which was asked for by the investigating officer. So she is very much cooperating.
So why you are apprehending?
The only concern is that she has received some amount into her account only at the knowledge of her husband, which has already been told to them. This is the only concern. She is in Guwahati, but she is living at 1130. I have also given the boarding pass. For a limited period, Your Lordship, only for 2 weeks. In the meantime, she will be filing application.
Because you are asking to appear before the IO
Tomorrow.
Tomorrow. Why you need?
Because we need to file anticipatory bail application.
File anticipatory bail. You appear before the IO because this 41A deficit notice only. Why don't you have?
Okay, for limited period, as Your Lordship deems fit.
And the subject from your
Lordship, not more than 7 days, Lordship.
You are Mr.
V. Jimma.
That's all. However, note from there, however, noting 41 is from the isolated to evidence. Yeah, then isolated by part but the behavior but that at the both one and after it after it now put in the photo the big but I for the big from as of or photo and photo and keep some protection from of the branch on the for right for today on
Today she is living. She is living today. She will appear tomorrow.
For but at 5 this context and research planet from Mizoram with state of Mizoram that in the development of of given some guidelines and the transit and for present for present it's trying from without background for transit for However, file can be made approach for that one from date of okay, for 1 week you are granted. So for a section can be taken again within 1 week.
1 week from tomorrow.
What one?
She is appearing tomorrow.
The one from today, date of order. From 1 week from today, you appear. I mean, file a regular, not regular, and 40 land, 40 down, 40 and go. Until 1 week, you will be in print.
Highly
obliged.
Actually,
with forwarded, a copy of order may be forwarded to the court below. I can court in either.
Not required. I think he will.
He will.
May I please, Your Lordship? Lordship, here several persons are all interim bail. Your Lordship is number 26 to 40. Your Lordship. I have annexed that orders. Your Lordship. Annexer E2, Annexer J. Your Lordship. Page number 37. Your Lordship order. Your Lordship.
What nature of case?
FIR is page number 16. Your Lordship.
Subject on this, all the peril, on the ground of peril, all the can be done. There may be some difference. Anyway, what is your case? What is your case?
Lordship.
Yes.
I am not involved, Your Lordship. I am a resident of that area, Your Lordship. At that time, I was outside, Your Lordship.
Outside?
Lordship.
Where is the FIR?
The FIR is page number 16, Your Lordship. In forwarding report, Your Lordship, any other accused person not implicated me, Your Lordship. Annexer B2, D. I have annexed the following report.
Yes, ma'am.
Similar kind of order was there
yes,
earlier.
similar orders are there, madam.
Orders are there.
Though, my lord, we cannot, my lord, support this kind of acts, my lord, but some orders are there, my lord. Interim orders.
Interim orders are there.
Yes. Fixing, my lord, on 21/5/14.
Some are 31st May, Your Lordship. Page number 37, Your Lordship. Similar to Your Lordship. Annexer Z.
Oh.
No way.
Oh.
First of May.
31st of May. Obligation.
Yes, CD received, ma'am.
In fact, Lordship, this FIR, your Lordship will find at page 11. And if your Lordship will come to page 12, Lordship will see that there was some manipulation. The allegation is there was some manipulation done at the behest of some officers where I was also involved. I am not an officer of the under the revenue, and my name was inserted. But later on, this was rectified, and the mutation was done in the name of the original person who is the complainant here. As on date, there is no manipulation at all. Therefore, Lordship will see.
So earlier it was.
The allegation is that earlier it was, and my stand before your Lordship is I have not signed any document. I did not apply for.
But you are the sub-registrar. Who are you?
No, I am not any of the officials. I am not any of the officials, Lordship. He says it was done in my name.
Oh, acha.
And Lordship, the forwarding, Lordship, if your Lordship will come at page 14, point number 10, that signature has been sent to the FSM, and if an opinion comes, Lordship, perhaps that would clarify things. But otherwise, Lordship, my instruction, it is a fact, Lordship, I have got contiguous plots of land nearby. I applied for mutation over my land.
Over your land?
That is contiguous plot of land. Perhaps, Lordship, that writing, but I did not apply for mutation on his plot of land. Lordship will see whatever is there in the diary, Lordship.
Yes, case I received. It is not the case that the present accused petitioner is the bona fide purchaser of that land. The allegation is that the informant that is owner of the land filed this FIR alleging that land was mutated. Originally, land belongs to the father of the informant, Mansur Ali, in the name of Mansur Ali. And later on, when his father expired, in the year 23, he came to know that land was already mutated in the name of the present accused person. Thereafter, when he inquired in the office of the circle officer, then he came to know that on the basis of a sale deed of 1982, land was already mutated in the name of the present petitioner. Then he, thereafter, he has also filed one application praying for, cancellation of that mutation. And that mutation was at present position is that mutation was already cancelled. And that order of mutation was done on 21/23. So now the case of the petitioner that in the nearby the land of the in adjacent to the land of the present accused informant, the land of the petitioner is also there, accused petitioner is also there. So wrongly the land of the informant is also mutated in his name. That is not the fact, my lord. Here from the case diary revealed, your lordship may kindly peruse the statement of the accused person and statement of Nitul Das, my lord. How this forged deed of 1982, my lord, Nitul Das is involved. He prepared here in this case circle. My lord, sub-registrar was also arrested. Some of the officials of the circle office and office of the Deputy Commissioner's office, some employees were also arrested. And during investigation, yes, that deed of 1982 was a fake deed prepared by one of the employee of the that name. He in fact admitted, my lord, and thereafter on the basis of that, my lord, sale deed of the year 1982, mutation was done in favor of the present petitioner. And the present petitioner has also filed application. After filing of the application by the present petitioner, land was mutated in his favor, in his name. Now how he can take the stand that, my lord, I am not at all aware about the land that is already mutated in my name, my lord. That cannot be the...
If I am a party to the fake land transaction, yes, whatever my friend is saying, I would agree. If I have purchased a plot of land by way of a fake lordship sale deed, how can I prepare a fake sale deed, lordship?
Because of
that fake sale deed, if at all has to be prepared by the revenue officials. I cannot do that. If a land is standing in my name, I do have my right to apply for mutation on that. Now, after that, if the revenue authority comes to a finding, no, this is not your land, and they have carried out an examination of the documents.
Not your land, but the land was, I mean, the
that I am not a
sale
party.
deed was executed in your favor.
That if I am a party to the sale deed, lordship, yes, whether that I am a party to the sale deed, whether my signature has been examined by the FSL, lordship, whether the signature therein is my signature, lordship, it is not merely on allegation, lordship. Anybody can say a sale deed has been prepared in my name, but whether I have purchased it, where is my signature?
If sale deed is not in his name, how on the basis of that sale deed mutation was done in his name, my lord? And in fact, those adjacent land, which is, my lord, adjacent to the, my lord, informant, those land, my lord, in the name of the father of the, my lord, present petitioner also, my lord, not in his name, my lord. My lord, your lordship may kindly peruse his statement, my lord. And in fact, that, my lord, sale deed 825782, that was in fact a mortgage deed actually, my lord.
Now, whether the FSL report at all says that the signature in the mutation application is mine, or that is one of the points raised by the investigating agency.
That was it was in his favor or in his father?
In his father's name, accused petitioner's father's name. Your lordship may kindly see the state.
Father's name.
Father's
His name.
Not now. His defense is that already adjacent to the land of the informant, he already possessed land of 11 bega 5 less. So without his knowledge, that land was mutated in his name. Later on, after he came to know about that fact, when Mondal, that is his defense, that after knowing from the Mondal,
very good person.
Yes, how can that be? He himself file an application praying for mutation on the basis of that sale deed. And in fact, my lord, if in that sale deed,
asking you, the sale deed executed in
82
was whether it was in his favor or in his father?
Because in his favor. Otherwise, my lord, if
his favor or his father's favor?
No, that land is what, because that was actually a fake deed, because that serial number and, my lord, was that is mentioned in that my lord sale deed, that was actually later on police came to know that that was in fact a mortgage deed. Your lordship, treasury list is also there, my lord. And now, my lord, on the basis of that fake deed of 1982, who is there now, my lord? They, my lord, filed for my lord for mutation, my lord. That was a fake sale deed, my lord. And if the name of the
That was executed in his favor or
that was executed in his favor, and if my lord not in his favor, how that mutation can be done, my lord? Only on the basis of sale deed is the basis for my lord for mutation, my lord. And if name of the present accused petitioner is not there, so how mutation can be done in his name, my lord? So on the basis of that fake deed, and in that fake deed, my lord, signature of the petitioner as a purchaser is there, and for which my lord mutation was done in his favor, and the sale deed is of 1982. He applied for mutation in 23. So in all these type of cases, my lord, this happens, my lord. And how they use all, my lord, fraudulently after using this forged deed, my lord, how manipulated, my lord, various government records, and thereafter, my lord, those fake, my lord, sale deeds also used in various civil cases, my lord. And in many cases, in civil cases, by submitting all those documents, in fact, the petitioners also obtain orders also in their favor.
No, I'm
which, my lord,
taken back by my learned friend's submission. Once he says it's a mortgage deed, once it says...
Mortgage deed was originally, my lord, that serial number which was submitted for mutation, that was in fact a mortgage deed, not in the name of the present petitioner.
Now, what does he want to say? Whether it is a mortgage deed or whether it is a sale
The
deed?
sale deed on the basis of which, my lord, that is a serial number 8257 of 82. That was a fake deed, and on the basis of that fake deed, mutation was done in favor of the petitioner. Then during investigation, while police has, my lord, inquired about that serial number and year, then police found that this is not a sale deed, this is a mortgage deed in the name of some other person. So, my lord, prima facie that sale deed which was submitted for mutation, in fact, a fake sale deed, my lord. Prima facie, my lord.
But later on, it has come to knowledge of this police officer that it was a mortgage deed, not a sale deed.
Not a sale deed, mortgage deed in the name of some other person, but using that serial number, my lord, they, my lord, prepared this fake deed and submit that fake deed, my lord, before the authority for mutation, my lord. And this happens in all. So, prima facie that sale deed is a fake deed, my lord, on the basis of which mutation was done, my lord, in favor of the petitioner.
No, এখানে বিরোধ কমা আছে না
And police has also obtained, my lord, seizure list is also there. That, my lord, deed of which was used for, my lord, mutation. My lord, in this type of cases, what happens, my lord? My lord, initially, because they are all, my lord, in connivance with the, my lord, various officials of the, my lord, sub-registrar's office, my lord, circle officers, and other personnel, my lord, higher officials is also involved in this type of cases, and my lord, for which, my lord, they were also arrested. My lord, what happened, my lord? Initially, they, my lord, find out a particular plot of land. Thereafter, my lord, after knowing their history and everything, my lord, about that plot of land, they prepared a fake sale deed. And that fake sale deed, my lord, in fact, there is no existence of that original sale deed before the, my lord, office of the record room of the, my lord, office of the sub-registrar. Thereafter, my lord, because all are in, my lord, thereafter, by using that fake sale deed, my lord, and your lordship, as because initially in many cases it happens that they lost an affair before the, my lord, police station, that they have already, the original, my lord, landowner has lost his, my lord, original sale deed, and in that regard, my lord, one GD entry in many type of cases, my lord. and thereafter, my lord, they applied for a certified copy of the sale deed. And now, my lord, entire, my lord, what happens? All these officials, my lord, role of the all these officials come into play. Thereafter, when they applied for the certified copy of that sale deed, or thereafter, this, my lord, on the basis of that forced sale deed, my lord, certified copy obtained by the, my lord, landowner, my lord, thereafter, that sale deed was used for mutation, my lord.
Now, whatever my learned friend is submitting, my lord, that is something that has to be proved by way of an evidence. I am before your lordship for bail. I am in custody since 6th of April, lordship. Whether my further custodial interrogation is necessary, lordship.
Yeah. I am just pointing out, my lord, how this, my lord, happens.
Whatever he says, lordship, I would not say that is not correct. That may be correct, but that has to be proved in a court of law, lordship, by way of trial, by way of adducing evidence. Because I have got something which is contrary to what he has submitted. Therefore, lordship, my respectful submission at this stage would be, lordship, no further custodial interrogation is necessary. Whatever they have sought for in the investigation, they already have. I am ready to face the trial, lordship. Lordship will impose any conditions upon me. I am ready to face the trial, lordship. Whether any further custodial interrogation is necessary, only that thing has to be considered by your lordship. In fact, I am told the officers involved, they are on bail. The officers who are the prime accused, they are on bail.
The progress of interest there.
Yes, my lord.
As far we have seen, there are progress of interest.
But that original deed, my lord, shell deed, my lord, he has not yet, my lord, handed over to the present accused person, my lord, as per the IO. Well, because the original shell deed is with him. Because, my lord, that shell deed not yet, my lord, collected by police from the present deed.
As part of IO,
Yes, my original shell deed.
But from your side, these were all, you have produced the documents or not yet produced?
Lordship, I do not have that instruction because his brother has approached.
Are you on police custody also? Earlier?
No.
Police custody was not.
From 7/4/24.
He was in police custody.
Police custody.
44 days or something.
No, 38 days. Today, my lord, 38.
No.
Oh, no, police custody, my lord. Police.
No, he was picked up on 6th.
6th, my lord. Initially, my lord.
Judicial custodian.
Yes.
No, my lord, police custody was there, my lord, but that record is, my lord, now forwarding report is not annexed in the...
Forwarding report is annexed, Lordship, but the date is not. Forwarding report...
7 days police remand was there, my lord. Police has forwarding
page 14.
Page 14, my lord, and thereafter, if, my lord, if further that was extended or not, I am not aware of it. Yes, my Sejam Kamrup में.
Okay, you can consider Sejam Kamrup में. But that's the direct. And then when your cooperation will be needed, appear before the IF. And as per his submission, one cell is yet to be produced. If it is with you, just produce it before the IF. Investigate has been.
May I please, Your Lordship? 439 application, Lordship. Lordship, FIR is on page 10, Lordship. Lordship, initially the FIR was registered under section 392, Lordship. But in respect of the present petitioner, If Lordship refers to page 15, later on 411 was added, and my allegation is only that much, Lordship, 411, Lordship. Stolen article is recovered from my possession, Lordship. Relevant para is, Lordship, on page 15, second para. After being satisfied that there are prima facie ground to proceed against the accused person under section 411 of IPC, the prayer made by the IO is hereby allowed. On prayer of the investigating officer.
Where do you take?
Page 15. 15, Lordship.
Where?
Maybe there is some filing error, Lordship. I have the original copy.
No?
One order has not been.
Have you, what, you have with you what?
Section 8, 411.
Adding of section.
I have given the copy, Lord.
411 is already there after.
FIR initially 392 was there in the FIR.
What?
Yes.
This is with you? No.
CD is with me.
No, not CD. It's not. Oh, CD is with you.
Yeah.
So subsequently 411 was added.
Yes, my lord, subsequently, but I have not gone through that because in his my lord, bail petition he has already mentioned 392 and 411, my lord.
I have mentioned in the petition, Lord, about.
From the case diary, my lord, it seems that he is the purchaser of that, my lord, mobile phone. In his statement, he stated that, my lord, main one accused is, my lord, Akash Pradhan. Akashok মই সৰুৰে পৰা চিনি পাওঁ তেওঁ মোবাইলটো 1500-2000 টকাত দি যায় কেইদিনমানৰ পিছত লৈ যাম বুলি কয় মোবাইলটোত একো নথিপত্ৰ লোৱা নাছিলোঁ that is the statement.
My fault is only that I have not asked for receipt of the mobile phone.
He is in jail for last 27 days 1940.
Local person, Lord. I have already proposed my statement.
I 400 get it connected to the present may come
Kamrup Metro.
Later on 411 edit.
Security look.
20,000 with one.
Obliged look.
CD was called for.
In this case, my lord, charge sheet submitted. The 75/24 dated 29/4/24.
Obliged look.
May I please, Your Lordship? This is 439 application, Lordship. The present accusation custody as of today 59 days, Lordship. And so far kindly come to page number, Lordship, 8, the FIR. And operating person, Lordship, will start from page number 11. Operating person. 11 FIR.
Yes.
And kindly come to middle portion of the FIR, Lordship. Middle. After that, I have apprehended both the alleged person, namely Saiful Islam, son of so-and-so, village so-and-so, and secondly, the Custodial Islam, son of so-and-so. I have seized the two boats made of suspected fake gold, weighted of 1.485 kg, and the second 1.835 kg respectively. And this Lordship and supposed to be delivered, Lordship, last three lines, Lordship. In same para. During the verbal interrogation, they stated that they were carrying the suspected fake gold to deliver to a person, namely Gulzar Hussain Lalu, who is involved in fake gold business. And they have also informed us and many persons involved in this dealings of business. And Lordship, my name is not in the FIR, Lordship. And suddenly, Lordship, and I have been arrested on 20. Lordship, and 18/3/2024. Kindly come to page number, Lordship. For Caesar list, Lordship. Caesar list, Lordship, page number 18. And on the basis of the statement recorded by the IO, Lordship, the co-accused perhaps take my name, Lordship. On that basis, Lordship, police visited my house, Lordship, and recovered description of seized articles, Lordship. And kindly come to page number 3, para number 3, Lordship. And these are the mobile and etc. Lordship. 1/2 piece of golden color boat weighing 1.02 grams, Lordship. And only that much is recovered, Lordship, from my house, Lordship. But my name is not in the FIR, Lordship, as usual as the forwarding report, the other accused person arrested. There is nothing reveals against me, Lordship.
What a code? Oh,
yes.
Kind of the both so.
Yes, well.
Now 10 gram costs so much.
Yes.
So 1 kg. People purchase this kind of.
Yes, my lord, going on, my lord. Why people comes, my lord, and for purchasing all these, my lord. So those people are also, my lord, involved in, my lord, this type along with these criminals. Because, my lord, for getting those fake golds, my lord, by, my lord, why they have come from first time, my lord, long distance to get all this, my lord, otherwise, my lord, this is an organized crime, my lord. What they have done, my lord, initially, actually, my lord, in many cases, what happens from the, my lord, social media, from Facebook and others, my lord, they find out the details of, my lord, various persons, my lord. Thereafter, they make phone calls, and if they make phone calls to 100 persons, at least 1 or 3 persons from all over India, my lord, later on, my lord, while they came here, my lord, come along with, my lord, money, my lord, for that. So what they have done, they also looted the money and also provided fake gold. In some cases, also not provided anything, only looted those persons, my lord, who come from out of this state. This is an organized crime, my lord, going on, and mainly from, my lord, Lakhimpur district, Bihpuria, my lord, There are various factories, my lord, in those places
very big.
for making all these fakes also. And this is the organizer. This accused person is also involved along with all these accused persons, and my lord, he himself admitted, and other accused persons also stated his name. How these persons are involved in sitting all those persons,
But my lord,
victimized persons.
no, but no individual person is affected here as per this contents of the FIR is
it is not required that in
but
every
whatever
case
lordship,
someone individually only basis of the information, my lord.
so lordship, length of detention may be considered lordship, but 59 days lord. 60 days lord.
60 days. No, my lord, edit section 489B and 489C is also there.
Sorry, lordship, but that is I have obtained the certificate copy and subsequently that is added this section. But in the meantime, I have filed this petition, lord. Subsequently, I
Because
can
some other accused
section may
persons,
be
my lord,
mentioned in
fake
the
currency
order,
also
lordship.
recovered.
That 489 and 489 is also there.
Lordship, prior, when I have obtained the certificate copy, lordship, at that time, lordship, that section was not added. And even then, lordship, and today, yesterday, lordship, I have come, lordship, and this is, I have obtained the certificate copy, lordship. So that is why I could not put this section in my petition. So otherwise, my lordship, my involvement and length of detention in this section may be, lordship, reflect in the order.
Regarding his involvement in 489 and 489.
No, my lord, thereafter, my lord, one Noor Mohammed was arrested on the basis of statements from some other accused persons. Those fake currency made machine and fake currency were recovered. From him, my lord, fake currency not recovered. But yes, later on. Otherwise, while all those persons are involved in, my lord, all those fake currency business, so definitely he is also involved. He associates well.
After stopping he was saved and I think he was saved by some mobile one code of being 1.0 from what from involved. However, but election against brought him does not case. Does made out it do not made out case. Court for but I find it I but what report out of
Yes. SDJM, my lord, not looking good.
but they appear everything
Yes.
CGM looking good, Lord. Deeply obliged. Obliged. Obliged.
May I plead the Lordship? Lordship, report 39 application, and I am appearing as legal aid counsel, my lord. In this case, my lord, petitioner was arrested on my lord 2621.
My lord, in this case, scan copy received kindly. After some time, I will have to go through the
Scan copy. My lord, my humble submission. My lord, since my lord 2621, my lord, she was in jail, my lord. She is in jail, my lord, and again, my lord, only on suspicion, my lord, she was arrested. And my lord, after going through in this case, my lord, trial court proceeding was going on, my lord. Already going on. Out of
she was arrested in connection with this case when
300 to 31 in case number
custody since 2621.
2621, my lord. Or again, my lord, in the lower court, 5 PWs were already examined. Only IO was not examined till today, my lord. And out of these 5 PWs, nowhere stated that she is involved in that case. My lord, my humble submission is this, my lord. Affairs also, her name is not there, and she is only 32 years old, my lord, young lady. And nowhere stated, and 5 witnesses there, my lord, hearsay evidence and seizure witnesses. Seizure articles witness, my lord, nowhere stated that I am involved in that case. Again, my lord, after going through the affair also, lordship will very much clear that, my lord, her name is not in the affair. My lord, long time detention period is hamper her life, my lord. Long time detention period, 21, my lord. Near about 3 years, my lord. Long time detention period, her life will be spoiled, my lord. She belongs to very poor family. Again, my lord, my humble submission is that she will appear each and every day when required by honorable learned court, my lord. So my humble submission is this, my lord, 3 years already. She is behind the bar, so my lord, kindly allow him. Any condition imposed upon her, she will obey, my lord. This is my humble and respectful submission, my lord.
okay, try to submit.
Yes.
And he has submitted all.
Yes.
Our both.
Yes. Yes.
Because it is 302.
302
and
with 30.
she was the wife of the deceased, or I don't know, just something.
Wife of the deceased, but nowhere stated that she is involved in that case, my lord. Another accused person. Her name is not in the affair, not the PWs, 5 PWs examined, nowhere stated that Manasis Soikia is involved in that case, my lord. So, my lord, she will appear each and every day, my lord, before trial court is going on in the stage of evidence, my lord. My humble submission is this. Kindly allow her to go on bail.
Yes, I will go for the scan copy and tag mark, my lord.
Highly obliged.
It was 54. One. Oh, AB. Oh, no PH. Huh? 20. Suppose. He will submit. Our commission I have already recorded. Inside that.
The 27 also started submitted.
Are you on interim?
Yes, Lordship. Actually, Lordship, in this case, Lordship, someone was received by us and we have appeared already before the trial court.
Yes, search sheet already submitted.
You have already appeared?
Yes.
Submitted long back or what?
Long back. Actually, on earlier occasion, the matter was left over, Lordship.
Oh, but
CS number, my lord, 228/23, dated 31/10/23. 31/10/23.
So now you have appeared or you are on regular bill now?
Yes, Lordship. As per my instruction given by instructions.
You are Mr.
Yes, Ali.
It was around 30. They are
Deeply obliged.
28, my lord, CD is not received, my lord.
Please,
Petitioner is in interim, my lord.
May I please your lordship? 438 bail application.
No.
They both are major. They are already married.
He is not receiving the case diary, but you are on interim, I think.
Interim,
Lordship.
So let it be continued.
Yes, sir.
Lordship, they have complied with the court order. They have appeared before the IO.
These are there.
Lordship.
But we have not received the case diary.
Lordship.
You are there, your interim will be extended.
Lordship.
No need to worry about. Just we receive the case diary.
Lordship. Highly obliged.
You are Mr.
A. Thakuria.
Accordingly, yes, what
On 4/6/24.
accordingly on 4. Your interim will be extended.
31.
Highly obliged.
30. My lord, in this case also petitioner is in interim, my lord. CD not received.
I'm on interim, Lordship.
30.
CD not received, my lord. Petitioner is in interim. 4th of June, my lord.
4th of June?
Yes,
sir.
Return 4th of June. Your interim will be extended.
Highly obliged, Lord.
Lordship, kindly adjourn the matter for the day. My senior is not available. He is out of station, Lordship.
He is out of station. Whether what happened, received case diary or
My
not?
lord, receiver CD needs to be updated. My lord, petitioner is in interim, my lord.
Yes, Lord.
You are on interim?
Yes, Lord.
You are MS?
Ardeka, Lord.
Ardeka.
Or 11/6.
11. Your interim will be extended.
Obliged, Lord.
May I please, Lord?
Yes.
In this case, my lord,
My case is like this, I have purchased the plot of land and the sale deed is at page.
We have received
Earlier, yes, my lord. Earlier, your lordship has rejected, my lord.
Rejected, my lord. On that day, my lord, while it was rejected, my lord, no documents were produced before this court. But your lordship is, if lordship goes by page number 18, my lord, it is a part of the sale deed.
page number 18.
Page number 18. This is a vernacular language. This is in vernacular language, my lord. This is the sale deed, my lord. Kindly see the area of the land, that is 2 biga to 10 lesser. And if we go by page number 21, your lordship may kindly see the dag number and patta number. The patta number is 53 and the dag number is 587.
In page number 20.
21. The last page of the sale deed matter. It is in vernacular. The Kheraz Miadi 53 number patta and 587 number dag. Now your lordship may kindly come to page number 33, which is an FIR, which was made on 27/12/2023. I have typed it out and originally also following money. If we go by the first few lines, my lord, sir, may I read, with reference to the subject cited above, I have the honor to inform you that I, the undersigned, along with my mother and 2 sisters, are the absolute owner and possessor of our ancestral property, plot of land measuring 2 bigas 1 kotha, 3.28 lesses, covered by dag number 578. My plot is 587. Actually, owner was the informant itself. I admit it that the informant therein, he was the owner of a particular plot of land. It was a big plot of land. He sold it, a part of it, that was 2 biga and 10 lesses, to me. And subsequently, he lodged an FIR saying that dag number 578, whereas he sold the property 587. But the patta, as we know, Asmali patta is always about 1, my lord, that is 53. We are admitting it. So at this stage, my lord, at the initial stage, no bail was granted to me, my lord. So as because the FIR does not tell you with the sale deed, my humble prayer is this, my lord, this is a different case as has been informed by the informant before the police station, my lord. I am the owner of another plot of land. So my humble submission is this, my lord, at this stage, this case may be considered, my lord, but subject to what my
lordship. Item 39 also same, your lordship.
Arising out of the same FIR.
We are the
One is, my lord, accused number 1 is the wife of the present petitioner, and the other 2 are brothers, my lord.
39. 33 is who? Who is
33? 33 is the Zakir Hussain. He is the main, my lord, accused person, my lord.
And
his
39.
Name is, and 39. 39 is, my lord, 3 petitioners. Accused number 1 is the wife of the present petitioner, and other 2 and 3 brothers of the present petitioner.
And this petition has been filed out of apprehension.
No, my lord, they are sufficient. Well, I will point out now.
It is somewhere similar to, I think, the item number 25, where my friend Mr. R.D. Chaudhary made the submission, but he was in custody.
That was, my lord, in this case, my lord, anticipatory bail, my lord. Now, my lord, all those grounds, my lord, here case diary is with me, my lord. All those police has done all these investigations, my lord. In this case, circle officer was arrested, sub-registrar was arrested, other, my lord, employees of the office of the sub-registrar was arrested. Your lordship has earlier perused the CD, and after perusing the case diary, your lordship has rejected the bill.
Zakir Hussain is the main culprit. Zakir Hussain.
Zakir Hussain, he is the main culprit, because in his name, it is not the case that I have purchased that land, my lord. This is the money received, my lord. That by way of paying this amount of money, I purchased that land, my lord. I am not the bona fide purchaser. These are not the cases. But here, my lord, by using that fake deed of 1990, in every case, my lord, sale deed is of, my lord, 98, 82. So in all these cases, my lord, immediately they have not applied for mutation, my lord. After long years, my lord, here, my lord, sale deed is of 98. In the year 2023, my lord, you have applied for mutation, my lord. And my lord, later on, my lord, during investigation, it is found that on the basis of a fake sale deed, here also, my lord, your lordship may on the basis fake sale, that sale deed number, which was of 1998, actually, in fact, that deed was between one Pum Pum Singh and with some other person. And they created by using that number, my lord, created a fake sale deed and submitted that document for mutation of the land in their favor. And later on, by using that fake deed, my lord, all these, my lord, officials of the sub-registrar, circle officer, my lord, done, my lord, mutation in favor of the, my lord, the present petition. Everything was done because, my lord, admittedly, my lord, consider huge amount of consideration is there, my lord. Maybe, my lord. Although your lordship has also perused the, my lord, earlier also perused the case diary, and these are not new grounds, my lord, because from the case diary, my lord, all those, my lord, facts are very clear how these, my lord, accused person, by using all these documents, my lord, fraudulently, my lord, my lord, transferred the name of someone other victim's land, my lord, in his name, my lord. These are serious cases, my lord, and this is not a BA, my lord, this is anticipatory bail, my lord. The custodial interrogation of the present petitioner is necessary. And regarding other accused persons, my lord, that is, I will leave it to your lordship because one is wife of the present accused and others regarding them, my lord, your lordship may consider, my lord, regarding that. But he is the Zakir Hussain, my lord.
Well, in this case, my lord, then I will have a little submission, my lord. All right. What my pain has stated from the case diary, that is clear. One sale deed is executed. Admittedly, one sale deed is executed. Whether that is fake or not, whether the police can determine it, if we do not go to the civil court. So, if we have to go to civil court, then we have to be present before the civil court.
Yes, well, forgery is the specific offense under CRPC.
All these records has to be collected from the FSL report, and all these things has to be examined. All this has to be examined, my lord.
And sub-registrar himself stated that, my lord, who is the executor of that, my lord, sale deed, that this is a fake sale deed. Well, there is no in fact, my lord, that original copy of that, there is no existence of in the record of the record room of the sub-registrar, your lordship, my lord. And all those records were manipulated with the help of the sub-registrar, my lord, sub-registrar, for which, my lord, he was also arrested. Some of the employees of the, my lord, office of the sub-registrar, my lord, all are involved, my lord. Yes, my lord. And in this type of offense, my lord, and more difficulty is that, my lord, if suppose somebody has filed a title suit before the trial court, a revenue appeal before the, my lord, revenue board, then what happens? Definitely, my lord, revenue board or my lord, civil court will call for the records of the, my lord, sub-registrar office or my lord, circle office. Then, my lord, court after perusing those records, which are in fact fake, my lord, will pass order in favor of the, my lord, accused persons. In many cases, that happens, my lord. Later on, my lord, it came to know that all these documents are fake. My lord, this is going on, my lord. These are serious offenses.
While RDF copy some as per that was from chapter number 3 of that number 5 and state was project for that method to get from okay, Kata number comprises that number 5 step 5 step but it from against where that number doing 5 7 not 5 7 and 5 is that that but it depends not from for from that number 5 not from that number 5 as it's a monopoly and for and important case that Mr. Bot with that after my home was that was without having any sub-registrar office there is no document.
Yeah,
When the existence of cell is not there.
Yes, well, original cell is not there, man.
Without or any document it was going to be a name of big I get FSS selected or not?
No, man.
FSS would get I but FSS it was accepted your petition stands rejected. In 39, you are the wife.
Right.
You are the wife and?
Wife and brother.
Wife and brother. Your husband. Your name, subject present petition. There are no, you are on interim.
In respect of one, there is interim, Your Honor.
One is the wife.
Wife. And for brothers, there.
Wife has already appeared, Mr.
Yes, wife is. Only in respect of petition number 1, there is interim order.
Yes, that's what I am asking. Whether she appeared or not. She appeared?
My lord, statement is not available in the case.
It was granted on 9/4.
9/4, yes.
What is your instruction?
So far, I have been instructed, Your Lordship, the petition number 1, she appeared.
Okay, petition number 1 will appear.
Yes.
Not available.
My statement is not because not updated till that much. So let him record. His record may be, his statement may be recorded.
So in that case, what?
Otherwise, my lord, I will have.
Otherwise, if there is any suppose from the record, if the direction may be given,
Yes.
that will be there.
Yes.
But he has not appeared. Everything has to appear before the IO.
Yes, ma'am.
Or whether it can be disposed of.
You will let him dispose of it.
But as per number 1, who was granted as per order dated 9/4. All petitions are not as number 1. Wife of one testified in and petition number 20 brothers in law of 1 are pardon. Your petition is
Obliged.
আপোনাৰতো উপায় নাই মই গম পালোঁ মানে এইটো দিব ব্যৱস্থা বেয়া সেইটো এণ্টিচিপেট আগতে দিয়ে আছিলে আৰু আপোনাৰ ইমাৰ্জেঞ্চিটো চাৰ্কুল অফিচাৰ এৰেষ্ট কৰিছে আপোনাৰ ষ্টাৰ্টিং পইণ্ট চাৰ্কুল অফিচাৰ এৰেষ্ট কৰিছে এডিচি এৰেষ্ট কৰিছে আকৌ তাৰ
Oh,
I have gone through the records, Lordship. As per office note, no records has been received and no service report is yet received, Lordship. So I am praying before your Lordship, if your Lordship take up this matter now, Lordship, only to continue the interim order, Lordship. The lower court proceeding is on 17, Lordship. On 10/4/2024, your Lordship has granted interim order. Services awaited, LCR also not received, Lordship. As per office note dated 13/5, Lord. As per office note dated 13/5. As per this record but till the order can go to the I'm deeply obliged.
I have gone for my lord.
Okay.
But my lord, perhaps my lord, he will come, my lord.
Not come.
Not come.
She has already
Lost.
her
Lost. It.
As for her submission.
Yes, my lord. First.
The present petitioner is in behind the bar since 2021.
Yes.
And she submitted that she is innocent, and 5 people have already been examined.
Yes.
And none of the witnesses incriminate her in
No.
the communication.
Yes, but yes, it is my lord. From the record, it reveals, my lord. Altogether, 7 witnesses now examined, my lord. So the trial is also my lord, going at a right pace. My lord, that is one thing, my lord. Secondly, my lord, from the PM, the body was found in the water, but the PM reveals, my lord, there are several injuries over the body, my lord. And the death was due to head injury. There you go. This is antemortem, my lord. And going by the, my lord, the record, my lord, it reveals, my lord, they are in a relationship before the death of the deceased, my lord. This petitioner and the another co-accused, my lord. So after that, my lord, they had such a plan to remove this deceased from their path, and accordingly, my lord, the co-accused have killed the deceased man. And going by the statement of the
No, body was in the road, on the road.
road, man, Panit, man, in the water, man. Water.
So they removed the body.
No, when the several people gathered, my lord, and after that, my lord, the body was removed from the pond, my lord. And after that, the PM is conducted, and after going to the PM, my lord, it has been found that, my lord, he was
Not
killed.
for only, not for the drowning,
Not
but the-
for drowning, but because of the head injury is the primary cause, ma'am, and other injuries are there all over the body. These are the facts of the case. And regarding her involvement, my lord, is very much, my lord, effective from the, my lord, CD part, my lord. I have seen, my lord, several witnesses have stated, my lord, they are in relationships, my lord. That has been confirmed, my lord. And
our relationship
with the other co-accused, my lord. Another co-accused is there, my lord. He is the person who actually killed the, my lord, him. Yes, information is given. And my lord, from the statement of the co-accused, my lord, it reveals, my lord, that his certain facts, my lord, is not aware to him, my lord. It was been revealed by her, this petitioner, my lord, that when he is going out from the house, what he will do, and what and whether where he will be, and also that he bears some 2,000 or something that rupees in his pocket, my lord. Therefore, he will go straight to the consuming liquor, and that will be a great opportunity to remove him. That portion, my lord, is very much, my lord. He is not aware of this. That other co-accused cannot be aware. It has to be revealed by her wife, my lord. So, from his statement stated that her wife gave the lead, his wife, this petitioner, gave the lead to murder her at what point he could attack him. Man. So, the circumstances are purely against this petitioner, my lord. So, my prayer is that, my lord, there is no ground of, my lord, sympathy for this petitioner, my lord. It's very much, my lord, a heinous crime, my lord. Hatching a conspiracy, my lord, only for their, my lord, illegitimate relationships, my lord. They kill one innocent person, my lord. And leaving a children is one child is there, my lord. This statement also have heard from one. Now only perhaps three witnesses, 3 or 4, my lord. Okay, at the fag end of the trial, with some observations that let the trial be completed as soon as possible. I have flag marked the positions, my lordship and Peru.
As per wait, but by all
No, regarding the main prime accused person, I'm saying only accused person. That
Prime.
Who killed the
No,
her.
there are only two accused. She and other one.
Yes, madam. But
so no other.
No, others, whether let me see, whether
The other
they are accused, some are just accused, but whether they are suspected, I'm just yes, they are not sent up. Only two accused persons who were one is the petitioner
one,
and another is our other. Only four accused.
And almost 7 no, almost 7 and the apart from other not grant bail which there is done in court with and the other going to Manoj Jofang, he is already on bail.
I have not on bail because he was earlier he was known as absconder. Thereafter, to check whether he's on bail or behind.
influence. Okay, it is detected.
Rejected. Okay. Okay. Thank you.
Maybe the loss of the 438 bail application was it. Last of the LCS call for receipt. So FI case 10.
Yes, 10.
So FI is case 10 not. Our submission is that on last 2/11/2015 at about 11 o'clock at night, in the night, Sri Gokul Bora of Gandhinagar and Sri Gokul Doctor of Rabarbari has stayed embezzled my vegetables situated near the Ganesh Mandir Makum Daily Bazaar and fled away. As the fire extended, the local people immediately extinguished the fire, for which the entire market has been saved from being destroyed. It is informed that both the miscreants has destroyed the handle of the tube well so that the fire could not be extinguished. The act of the miscreants may cause damage to both life and property of the Makum Daily Market. It is therefore paid to take appropriate action. This is the case of it. The case was registered in the year 2015 lawsuit, and it was succeeded in the year 2021 lawsuit.
It was shown as a default.
Yes.
One Gokul Purva is also there and one Gokul Doctor.
Yes. That petition was Gokul Doctor.
Yes, then what had happened now?
The petition is ready to face the trial lawsuit. Only lost some protection. You will appear before the trial court lawsuit.
Have you already received any
Yes.
notice for summons from the court?
Yes. Not yet. Here, Lordship will kindly come to page 19, Lordship. And for Lordship, page 20. It speaks for appearance, Lordship. Also, he will appear, Lordship. He will name some protection is appear, Lordship. He will face the trial, Lordship. He can appear in the before the trial court and before a bail application. The same will be considered in merit court by the court below. In the LCR Lodge, we find that several attempts were made to search him, Lodge, but he was found absconding. I have flag marked the house search, notice search. My lord.
Now it seems that is the and in spite of several house search possibly could be arrested by the IUPD as we are going. Now even after filing the 15th of summer, you filed an application on behalf of was also allowed that there are obviously there may be a reason for apprehension of arrest. I can understand. But the conduct
Mr. Petitioner will appear before the trial will kill them some protection. Will appear before trial. Next day fixed.
You think the big case.
Not a big case.
Maybe if up to the freedom.
Listen, he can
NBW is
appeal.
issued against you? No.
What's that?
NBW is
No,
not.
no, no. NBW is not a serious matter. NJ Gogoi. I'm on behalf of R. Pukon.
You are Mr.
NJ Gogoi.
you appear okay, till 10 days were being protected. Appear before the internet court.
Highly obliged.
Petitioner
is an interim document. It has not been received.
Updated was called for updated.
Lordship, June 7, Lordship. 7 June.
7.
Much obliged.
Same prayer, Lordship. Petitioner is an interim.
CD is not available. Lordship, can you fix it along with AV number 961 arising out of same FIR, Lordship? 961 2024. Which is 1. Yes, Lordship.
Fixed on 10th of June.
Fixed on 10th of June.
It will be extended according
All right.
CD received, Lordship.
May I please, Your Lordship? So we have this case, Lordship, the earlier in motion stage, Lordship, petition number 1 and 2 is interim granted, Lordship, and all the petitioner father, mother, and son, Lordship. And only file the FIR, find FIR page number 11, Lordship, and father, mother, and son.
The parents were granted.
Lordship.
Also here the petitioner number 1 and 2 already on interim. And number 3 was not granted interim, Lordship, and your Honorable Court was pleased to ask for the medical report, Lordship. We have received the medical report. Here all the injuries are simple, blunt, Lordship. Only thing, Lordship, it was the injuries are in the head, Lordship, but it has been categorized as simple and blunt.
So, my Lord, the 326 will not affect. Otherwise, Lordship, I am very clearly mentioned in my petition in para number 5, page number 6, Lordship, as per the instruction, Lordship. And the earlier, Lordship, the informant son, Lordship, got a bike accident, Lordship, and subsequently he got head injury, and they are the same locality, Lordship, and he is under treatment, Lordship. But on that day, there was some altercation, it is admitted, but no such marpit was not severely there, Lordship.
And these petitions, they have appeared?
Yes, yes.
Where it's meant to be for the court of
Lordship.
for the court of.
Lordship, it is 438, Lordship.
Oh, sorry. So one for one and it will be active and three. There will be some
Lord.
they all one.
Lordship. Published, Lordship. Published. Published.
38 Lordship, CD has been received. The Lordship, interim was granted, but his statement is not in the case dialogue.
Can we see the CD is up to which?
Lordship, CD is up to
Last note.
Last note is Lordship of 23. 7/12/23.
Where?
23. But Lordship, the thing is, the interim order is in the case day, Lordship.
I have appeared.
Interim order. So he must have appeared, but his statement is not in the case day, Lordship.
Because the interim was granted for 4 court.
Yes, 4/4/24.
But since after 12, what was the date?
7/12/23. Lordship.
7/12 there is no anything after that.
Lordship. Lordship, because he must have appeared, because otherwise, Lordship, this order will not be in the case day, Lordship.
I have appeared.
So which one is the submission that is available is recorded?
Lordship.
For particular.
Lordship.
There evidence or there it's not for us.
Lordship.
Hard Mr. MR and hard
Ini appear করতে না হলে আপনি না পাইবেন appear করলে কি হয়ে গেল
Yes. It can
10/10/6.
Recording cannot give them interim.
I am on.
Charge sheet has been submitted.
Yes. Are you going to eat it?
Yes, yes, sir.
You are in.
I appeared and recorded my statement.
Huh?
I appeared before the IO Lordship.
Yes, number.
CS number 20/2024, dated 30/4/24.
RJ, sir. Only one.
your interim clearance bill will be extended for 10 days. Within 10 days, you appear before the learned trial court below and appear.
Lordship, may my humble submission can be on till receipt of notice and appearance on trial, Lordship. Till receipt of notice from the learned.
Within 10 days.
May I please, my lord?
It has been received, Lordship, and interim was granted, Lordship. However, Lordship, before the interim also he has appeared before the IO, Lordship, and the IO has issued him 41A notice, Lordship. He is cooperating, Lordship, and I have seen it from the IO's note, Lordship.
And will cooperate with the investigation as and when required. Bidas.
Bidas.
Well.
dated 29. To be interpreted.
Deeply obliged.
May I please allow? Report 38 application, my lord. What happened? FR is at page, my lord.
Brontul PS case 8, my lord.
Yes.
Day before yesterday, my lord, this matter was listed along with other 3 matters were also listed, my lord.
When?
Yes. On that date, this matter was not taken up, my lord. Because my lord,
Other matters are when?
on 22/5, my lord. 17/5, one matter BA listed on 17/5 and other matters on 22/5.
My lord, I am in no way involved, my lord. I am from Boko. An occurrence took place at Dharamtul. Truck was looted by some unknown person. And on false information, they have seized my coconut. My coconuts are all green coconut. Their stolen property is dry coconut. I'm sorry, coconut, supari, dry supari, Erica nut. So my lord, police came to my house. They wanted to seize. They have taken away my all fakes. I have not come for Jimma now. Now I have come for anticipatory bail, my lord. Kindly protect me, my lord. There is no case of 395 against me, my lord. I hope the diary also reveal that things, my lord. I have no action in this matter, my lord. I am also this Ericanot businessman of the Boko, my lord. I am regularly purchasing from the local market as well as from the village to village. We go and collect the coconut in this supari, and we used to get it dry thereafter. After getting it dry,
colored it, then we'll send to market, my lord.
After coloring?
Beg your pardon?
You colored it also?
Color means there is a provision for some permissible color is there for supari.
No permission for coloring is
Yes,
there.
yes, it is there.
So, yes, some of the suparis, there is also other purposes used.
For that purpose, suppose
Yes,
coloring is applicable, that is the that supari or the dye.
But it is not an
used for the other purpose.
Yes, not injurious to health also.
But regarding the present case, my lord, police has, my lord, although recovered 1612 kg from his possession, and one of the Kosal Agarwal, my lord, who stated before police that he purchased another amount about, my lord, 3500 kg from the present petitioner. My lord. Let him appear, my lord, let him statement be recorded before police, because case diary, my lord, already today is not available with me. But regarding the present, because your lordship has also perused, my lord, it is not from the case diary. It is not that, my lord, the petitioner is not he is the purchaser, my lord.
Case diary be retained?
No, my lord, because regarding other cases, your lordship instructed to, my lord, whether, my lord, because CD is lying here since long, my lord, so IO has taken yesterday, because regarding other cases, your lordship has directed, my lord. So it is not that this person is not, he is the subsequent purchaser of those stolen articles, my lord, and the persons who are involved in, my lord, hijacking of the truck and looting of those materials, their statement is also available. From one Akabur Ali he purchased, and thereafter police recovered 1612 kg, and thereafter one of the, my lord, subsequent purchaser Kosal Agarwal, he also stated that I have purchased an amount without any document purchased 3500 kg from the present petitioner, my lord. So these are the materials against the accused, my lord. Anyway, my lord, considering that he is the purchaser, let him appear, a statement be recorded, and thereafter.
For up not right. What is the
Beg your pardon?
not with right but
I couldn't follow, man.
you deal with the business of not right canal, but
My it is a green
Green
canal.
you appear before the IO?
I will appear. Give me 10 days time or 7 days time.
7 days time.
7 days, because other matters are fixed on 22/5. 22.
All the other matters.
Yes.
Let it be on 22/5.
Appear before the IO.
Development.
Mr. Botakot, how many are again left for the Dharam program? We are also going by the case diary. Me also, I have several times I have done the case diary.
Yes, ma'am.
How many are there again left? For the Dharam one.
Dharam one, my lord. I will have to, my lord, get the instruction from the IR to tell how many.
5, 6 are there.
Yes, because IO yesterday also IO he contacted that CD is urgently required for, because in some cases he wants police wants some of the accused persons. I will get the instruction. Yes.
Yes, what?
May I please? Lordship, here in this case, Lordship, LCR was not called for, Lordship, although the sentence was suspended, Lordship.
Yes, you got treated as is not called for.
Not called for.
You are appealing for
Correspondent number 2.
state is 1.
Yes.
You are Mr.
THO there.
Understood.
Yunanda.
Report not called for. Not called for. To after few weeks it will be there. We are calling for the case.
Sure. I'll
Very special, actually.
Was there any incident?
Lordship, the sentence was suspended till disposal of the present.
It was also suspended.
Already suspended by the order dated 29/9/2022.
Okay.
But in this case, Lordship, they are supposed to, Lordship, file an affidavit, Lordship. No affidavit has been filed.
Your Lordship, we need some more time to file affidavit, Your Lordship. I'm appearing for respondent 2 and 3.
Yes.
And for one,
I'm for respondent number 2 and 3, Your Lordship. 1 is CGC, Your Lordship.
so you are government.
Yes, Your Lordship.
One for one to additional PP were appeared. Already.
No, one is, Lordship, Union of India.
CGC should be there. But as per order dated 21/7/2023, it's written that Mr. Borthakur appeared for one. It should not be, I think, but
We got a learned PP.
is for order dated 21/7/2023.
Yes, Lordship, that is wrongly reflected. In fact, in that case, Lordship, K.K. Parashar was there as Solicitor General, Lordship, CGC, Lordship, on behalf of Lordship, Union of India. But here, Lordship, wrongly is there.
So from the government side, you're going to file with your affidavit in office.
Yes, Lord. Argo boy.
Do you stay with how many?
4 weeks time maybe not.
May I please, Malad, this is 482 application for quashing. Malad, your lordship will kindly, Malad, take for disposal, my lord. This case may be taken up for disposal, my lord. Now, the thing is that, my lord,
I want to
kindly submit, my lord, your lord.
Just one thing. The last occasion,
Yes, Lordship.
most probably we provided some time.
Yes, Lordship. But he is still in ICU, Lordship. So
Who is in ICU?
the complainant, Lordship.
Informant, my lord.
Informant, sorry.
Your lordship has directed, my lord, them without fail. That is the position, my lord, last order. And my thing is that, my lord, the proceeding is going on in lower court. And this last order has been issued, my lord, that you should appear strictly without fail on 1st of June. And my lord, record has come, my lord, scan copy. And your lordship may consider my interim prayer also on the basis of my additional affidavit, my lord. Their part they can continue after, my lord, this case is taken up for final, my lord. Because, my lord, a false FIR was lodged against me because I have filed one writ petition in High Court seeking compensation of our villagers' land, my lord. And that copy of the writ petition is also, my lord, in the scan copy of LCR, my lord. So it's a, my lord, sections are, my lord, it's not a, my lord, POSCO, neither, my lord, it's a murder case. It's a very small section, my lord. 448 is house trespass. Section 186 is obstructing, my lord, public servant. 294 is obscene.
Days of the proceeding at present.
My lord, I have the latest order. Yeah, please. Dada. This is the last order, my lord. I have been directed to appear on 1/6 without fail because earlier also we have taken time, my lord, 2-3 occasions because respondents are asking for affidavit. So my
So
son,
as a whole, how many accused persons?
my lord,
As a whole, how many accused persons are there?
my lord, these two petitioners only.
Only these two.
Yes, my lord. What happened, my lord? These two petitioners went to submit a copy of the writ petition, my lord.
That come from.
Yes. My lord, FIR is at page 10, my lord. Yes.
In that case, we have to pass an interim.
Yes, my lord.
Because on the last few occasions, most repeatedly for seeking time. The last occasion, considering your submission, we granted time by the composition.
So, may grant the interim and seeks a short date for final disposal, my lord.
Teacher, man.
Yes.
As per order, the phone number was that 5. Without but sub not take instruction from right and still I the order. It posted out one and for the case number is
मतलब PRC 75 2023 मतलब it's in the first page मतलब PRC case number 75 of 2023 pending in court of Lanet CGM Dima Assam.
pardon. By the so Mr. Sharma, I see how many weeks you need because considering your problem, we state the procedure. Otherwise, it was person he is still in ICU. I can understand. Maybe critical.
Lordship, matter may come up on first week of June, Lordship.
First week of June. 6.
My lord, 6 I will be out of station, my lord. Any date, my lord, on 11, my lord. Next 11. Obliged.
May I please your lordship? 482 application, lordship. The fact is that the petitioner is a joint account holder of the office of her husband, lordship. The husband of the petitioner issued a check without signing from the petitioner, lordship. The account was a joint account holder.
So your petitioner is a joint account
Holder of her husband, accused number 1, who was a edit, and accused number 1, and accused number 3, myself, lord, without signing the check. But account is joint account holder, which is mandatory as per 130 of NI law.
Though it was a joint account, but your signature was not there.
Not. Therefore, the Lanet court called for the LCR for verify of the sick for passing the interim order for state operation.
No. Who called for the case report? The Lanet court.
Lanet.
So then it will be verified by the court.
An order dated 13/12/2023.
Wait, is correct?
No, this court, lordship. Call for LCR, this court, lordship. 13/12. LCR.
This court.
This court.
Order dated?
For consideration of interim order. Order dated 13/12/2023. Whether the petitioner sign or not.
But yes, that was the order for
13/12.
for interim relief.
Interim relief.
So you are not going. You are not ready for the final hearing today.
Lordship, this is settled proposition of law. This criminal petitioner may be disposed for setting, quashing the proceeding also, Lordship.
No. I am not there. You are for only for interim prayer, or you are going to, argue the matter as a whole.
Interim prayer, Lordship. Because the
Why
state of the
only
operation, because the warrant of arrest is already issued to me, Lordship. Absence of interim order, stay of the operation of the NI CR case 595/2021. I will be facing the trial for ABC process of law. Because of well settled position of law, account holder, joint account holder must be signed, both the account holder, Lordship.
So you are on supreme.
In Lordship.
This is the LCM.
LCR already received. Can copy of the
So, your husband is?
accused number 1, who issued the check to the respondent number 2 for payment of some amount of rupees 50,000. The check was dishonored due to signature not as mandate.
This is the check we have received,
Not yet.
where obviously one signature is there.
No. Settled provisional lordship, one apex court judgment also said there that dishonour was a
Because
criminal.
there may be difficulty on his part because warrant of arrest has already been heard. So if there is not interim or if it is finally heard, so
State operation of 595.
not state that
Ill disposition of the criminal petition.
May submit below. Instead of passing an interim order, my lord may dispose of this application. That order may be kept in abeyance till the time he appears. Because my lord, the position is very clear. Yes, of course, the petitioner is not a signatory, my lord. If she is not a signatory, then entire proceeding cannot be quashed. The person who has made the signature against him, the proceeding will continue. That is what the Supreme Court has already stated. May I place one question? My lord may come to at the last but one page, para 22. May I read, my lord? In the light of the above discussion, we hold that under section 138 of the Act, it is only the drawer of the check who can be prosecuted. In case on hand, admittedly, the appellant is not a drawer of the check and she has not signed the check. A copy of the check was brought to our notice, though it contains name of the appellant and her husband. The fact remains that her husband alone put his signature. In addition to the same, a bare reading of the complaint, as also the affidavit of the examination in chief of the complainant and a bare look at the check would show that the appellant has not signed the check. We also hold that under section 138 of NI Act, in case of issuance of check from joint accounts, a joint account holder cannot be prosecuted unless the check has been signed by each and every person who is a joint account holder. The said principle is an exception to section 141 of the NI Act, which would have no application in the case in hand. The proceedings filed under section 138 cannot be used as an arm twisting practice to recover illegally due from the appellant. It cannot be said that the complainant has no remedy against the appellant, but certainly not under section 138. The culpability attached to dishonour of check in no case, except in case of section 141 of NI Act, be executed to those on whose behalf the check is issued. This court reiterates that it is only the drawer of the check who can be made an accused in any proceeding under section 138. And my lord, accordingly, my lord, at last para, my lord, the proceeding against the other person who did not sign the check has been quashed. At para 24, my lord. Under the circumstances, the appeal deserves to be allowed and processed in criminal case of so-and-so pending before the court of learned metropolitan magistrate so-and-so. He quashed, accordingly quashed against the appellant herein. The appeal is allowed. So, my lord, the other person, he must face the trial, my lord. So, that is the position of law. So,
Lordship.
That is
Lordship, this is, I think, everything process of law, Lordship. Because the other provision is there. Suppose accused number 1.
No, but the question is that you may not sign, but your husband or whoever, he signed it.
Yes, signed.
So, as per submission or as per the view of the Honourable Apex Court, is that you may not be prosecuted, but the other one cannot be absorbed.
Yes, that is the law, yes.
So, here you want to say what from the
Same judgment, Lord.
My lord will let me dispose of this application on that ground.
The same judgment?
Lordship.
Okay.
Okay.
Oh. There is another one judgment that they produce, this one is also the same one. Similar line.
Hmm?
para you want?
My lord, yes. Para my lord 7. May I read what? Even in the case of joint liability, in case of individual persons, a person other than a person who has drawn the check on an account maintained by him cannot be prosecuted for the offence under section 138 of the Act. A person might have been jointly liable to pay the debt, but if such a person who might have been liable to pay the debt jointly cannot be prosecuted unless the bank account is jointly maintained and that he was a signatory to the check. R. Chakraborty.
Huh?
R. Chakraborty.
R. Chakraborty. Mr. Bora that the present petitioner and the present petitioner along with her husband had a joint account. In which bank you had a joint account? In which bank you had a joint account?
United Bank? Union Bank, Lord.
Union Bank.
Union Bank.
Which branch?
Union Bank, Moidamgaon branch, Guwahati, 28.
Joint account in Union Bank. In the Union Bank. The bank of Union Bank. Moidamgaon branch. But it never put any signature in the check for which it is not again present petitioner along as an number along with her husband one as number 1 and I 4 City of Kampu Guwahati complaint and I 595 transfer for GFS 5 company. What is the that considered prayer scored by order where I call for the scan copy of the verify whether the signature of the petitioner number 1 it was Mr. Bora further submitted that the present one it would be an and that context of then effect for basket number 1 people. Check it out there as not 9794. Drawer where and people John not put the take it sign by first the not put put there are the power like for what joint account are but the effort so like I can put that but it is and given from and what object one and one that and I find it exercise power for what is it that edit the number in 8 up 8 pending put that here come your cognizance has been taken
Yes, that's it.
both for boutique
And all, against the husband, my lord, the presumption has also already been drawn, my lord. So he cannot escape trial. My lord.
accused number 1 your husband is Nasiruddin Ahmed.
Nasiruddin.
Number 1
Accused number 1.
so against the entire
yes
that what
Highly
and
relevant.
against the accused number 1
Highly obliged.
all right.
and here is awaited right
Lordship, the husband and wife joint petition, Lordship, quashing the proceeding, Lordship. They are the amicably settled, Lordship. The LCR is not necessary, Lordship.
Who is the
Both are living together, Lordship.
21 LCR not available.
They are not available. He is submitting that they are husband and wife.
Husband and wife.
Which section?
Wife is file affidavit, Lordship, page 19, Lordship.
Petition 100.
They are amicably settled, Lordship. That they are living together, Lordship, with child. Lordship.
No, but why don't you file a joint petition? You can file a joint petition, but this is not a joint petition.
The Lordship, and file additional affidavit, Lordship, the wife,
I
Lordship.
don't know who is she filed the affidavit or not. They can't.
Joint compromise petition upon file. Okay.
Where is the affidavit?
Page 19, Lordship.
19 is it your additional affidavit? Is there any affidavit sworn by her?
Wife, filed by wife.
How she can file by what?
The earlier order is reflected the file additional affidavit by the wife.
Filed by the wife.
Wife.
How on the under what can you keep it?
The Honorable Courts was passed order, Lordship.
In which order?
Surabha Begum.
Sarufa Begum, my lord, is petitioner number 1.
Who is the husband?
Petitioner number 1. That is why fire.
Then it's a joint petition.
Joint
petition. Right?
Just saying that
Yeah.
that is not done. Apart from the petition, one more additional affidavit was you were asked to file in one additional affidavit.
Yes.
Because basically based on
498.
498 days. They are living together with child, Lordship. Husband and wife. Amicable, after amicable settle, they are residing same house, Lordship.
the amicable settlement compromise deed had to be annexed.
Lordship.
The compromise deed.
A compromise deed is not there. They are orally, Lordship. Both the family members are amicable settlement.
Later, whether in the trial court they have submitted anything, perhaps they have submitted the trial court.
Trial court has not power to quash the proceeding.
It's not compoundable.
Not compoundable.
Not
So
compoundable.
whether anything they have submitted.
So what is the stage of the case at present?
Appearance.
Appearance. Good.
Because the affidavit also was by only money route.
No,
You don't have any other signatures to compare with.
Another additional evidence for wife, Surabha Begum, case 19 law. And in petition is the wife.
FIR from the FIR.
Was the FIR?
I have also copy is not with me. That is
Oh.
the problem.
FIR is also not.
Yes.
Do you have the original FIR with you? FIR.
One copy, page 13, my lord.
Page 13.
Lordship. The vernacular. Yes. That's so it was coming on my thinking. So it is my thinking.
2013 এতিয়া হ'ল হেৰি এইবছৰ 10 বছৰ 11 বছৰ
Sheet also filed on 2013, madam. Sheet also on 2013. Yeah. So what is this? Yes, madam. What is the stage in the proceeding?
No order.
Yes, no order. Yes. Not fully. Some
Because actually not by her.
yes, some
by the number 2.
number 2.
Call for this
No.
case record.
Yes, sir.
And it's okay. Now
It's
they are
okay,
husband
ma'am.
and wife
They are-
together. Right. There is the same signature or not.
Yeah, perhaps not. Sometimes.
Many other.
Same signature on the second নহয়
মই যেতিয়া কৰে মই তেতিয়া কৈছিলোঁ ডিফাৰেঞ্চ আছে ইমান বছৰ আগত কৰিছিলোঁ হৈছে
মাতি দিয়া
Why in 2013 and now we have come for compromise?
the NBW accuses the husband then they are the knowledge the pending the case NBW issue against the husband
The matter by some part similarity is there.
Yeah,
But,
last part is
last part is all bit doubtful. Otherwise,
he is also
some difference I asked the wife lordship the petitioner number 1 lordship the signatures some minor the dissimilar lordship
yes, ma'am. He is also inquired as per his person.
After
Yes, I did.
then the signature I told to the wife lordship. He said about 11 years before the signature.
No.
Yes, Lord, how much is it? About 3 years.
If that
As a petition was instead of very inquiry petition is a file তাতে অর্ডারটা লই তাতে petition দেওয়া হয়েছে এইটা মানে ফার্স্ট প্লেস এটা কি যাওয়া যায় পয়েন্ট
number 1 and number 1 and are like
petition to দিও
effort was lost by as per order. Bye.
Deeply obliged.
May it please your ladyship. Ladyship shall kindly have a look at the last order.
Last order is
18324. Passed by this honorable court. Last line, Lord Ladyship. Interim prayer shall be considered on the next day. This petition challenges the DV case number 148 of 23, Your Ladyship. The proceeding has been initiated with a view to harass the petitioner, and the annexures placed herein shall substantiate how she has filed a false case. And the ladyship shall kindly come to page 82. Here she has made out
whether we are hearing the interim relief, he has already appeared.
Yes.
You are already appeared.
Lordship, I am appearing on behalf of S. Bhuya, MS.S. Bhuya, respondent number 2, Lordship. Lordship, what happened yesterday, she went to Walpara for some law and order situations, she couldn't come appear today. Lordship, may take it up this matter next week any date, Lordship. There is some personal difficulty.
What I am saying, obviously there is the order that interim shall be maybe considered, shall be or maybe whatever be considered to take place. The question is that we have already received anything. Whether LCA will be required for that or not. Because otherwise we can hear the matter finally. If we fix a date on the next day, or if the interim has to be considered.
If my learned friend can say
then your ladyship.
No, for consideration of interim she is present, that the interim can be considered because the LCA has also not been received yet. So that is the. So if you
Lordship may call for the LCR.
Call
In
for
the
the-
meantime, on the next date, the S. Bhuya may also be appear.
No, but she is pressing for interim now.
On the
So
next
this
date,
is
may
the
he-
case.
She has filed that interim application now. That's in the that is
interim application for any maintenance or not?
interim relief, and the relief that has been prayed for is that to keep one of the interim relief that she has prayed for is to keep this petitioner away from his two sons, Lord, Your Ladyship. The totally absurd prayer has been made. So till such time, the matter is heard, Your Ladyship.
But if such kind of prayer is supposed made, this is within your knowledge. So you can appear and definitely you can file your objection and all. So that may be considered by the DI. But they generally proceeding in a DB Act, we are not supposed to stay the proceeding because it is a filed by the whatever you can say it may head us to, but in that case matter may be finally heard and
If I may just have show this, rely on this judgment passed by the Bombay High Court has clearly stated why these powers of 482 should be exercised by the court even in a DV proceeding. Although the 2012 Act was brought into the statute book to protect the women folk, but where the proceedings are malicious, and then your ladyship's court can definitely go into it.
for entire watching the thing.
Yes.
So that will come after hearing you. That will come after hearing you on the matter of the case. There may be a good case for watching. That
Yes.
I'm not denying. But the question is at present, interim for consideration is a bit difficult because it is duty matter. Or that apart, if such kind of prayer is made for the interim release, whereby you have just stated that he will not be allowed to contact with the minor child and all. In that case, you can appear and file your written objection, whatever. Obviously, without hearing you, that no order will be passed because you were there only. So, if that is the position that he is taking time for because this most probably dinner is not. So, otherwise, if you call for the LCR, then it will take some time to receive
That is
the
better
LCR.
to
For your
call for
hearing
the
your
LCR.
interim may be a bit difficult.
To
Or
call,
otherwise,
your ladyship can call for the LCA.
we can call for the LCR.
Yes.
Then obviously it will be after 2 weeks only.
That will do.
H. Agarwal on behalf of MSSB. SB.
SB.
Yes.
As per story is there, is not received. What it? Service is completed. As what for? Probably only due to the expert is not get called for this call for the this and it will be made as
Much obliged.
So, my lord, 8 appeal, my lord. Yes, my lord. Kindly allow some time for taking steps. Earlier, my lord, steps not returned, my lord. If another order issued, so let it come after 3 weeks, my lord. Steps.
Before it be free, some more time to take.
No.
My Lordship, it is a case against acquittal under Section 138 of NI Act. Lordship, it is a prima facie case of conviction because it is the respondent made his statement where he admitted under Section 313, he admitted the legally enforceable debt and liabilities and also admitted the issuance of check in discharge of his liabilities, and his signature on the check also remain undisputed. So this constitutes the offence under Section 138. That's it. So even then, this trial court has discharged the respondent from this case. It is a prima facie case of conviction. Yeah.
I am appearing in sole respondent. I may be furnished a complete set of documents. I may be furnished the complete set of petition, not incomplete.
Yes, I have filed. I have given the copy of the memo.
No, this copy has already provided.
Oh, yes, final that copy is not given.
And page is also short. Yeah. Not complete. I am legal aid counsel. Complete no होगा
only liquidity. No, piccolita. Chips.
On the night plate Lordship, I have not complete copy. And today I have first time appear before your Lordship. No. I will submit my submission on the next day because copy is not complete.
Actually, Lordship, inadvertently the copy of leave petition is given to this country instead of this. Yeah.
Incomplete set.
Next date. Lordship, matter may be fixed either 3rd or 4th June. Either 3rd or 4th June. Yes. Either 3rd or 4th June.
Obliged.
That's me, 4th June.
Yes.
May I please, Your Lordship? This appeal has already been admitted. Today is, my lord, that missed case for, my lord, suspension of execution of sentence and releasing him on bail, my lord, that is my prayer. This judgment is dated, my lord, 19/12/2022, And my lord, about 2 years, 1 month, he has been punished under section, my lord, 10 of the POCSO Act, my lord, and he has been sentenced to RI for 5 years.
RI for 5
years. And about 2 years, 1 month, he is in the custody, my lord. He is aged about 65 years of age. And my lord, in this case, the victims has not been, her medical evidence has not corroborated because on the very next medical was
What kind of medical?
my lord,
What sort of medical?
it was my lord that fingering was done.
I don't know what it is, that I'm asking.
Yeah.
But it is there. And obviously, not it is a benefit section, that's what will come there.
Is that from the
it will not
medical
give this
evidence
for
it is
them.
not there, but allegation is there, my lord.
Anyway, whatever you're convicted under section
Under
10.
section 10, my lord.
So why you think that there could be an acquittal and not? Is there any ground?
My lord,
One
mainly
is
on
not
this case, my lord, if we go through the my lord, evidence of the my lord, mother, PW1, and my lord, one defense witness was also examined. And on that very day, my lord, there was a Shiv Puja in the house, my lord. In the house of the accused appellant, my lord, there was a Shiv Puja. And my lord, this defense witness, my lord, he was all along there in the my lord, Puja, my lord, till 3 p.m., my lord. So, in his cross-examination, my lord, there was no suggestion that he was not present or like that, my lord, it was not there. In that case, my lord, the defense witness and my lord, the prosecution witness, even the my lord, mother has also stated. And he is my lord, family members also, my lord. His one daughter is my lord, his granddaughter. She was also there in the house. She was my lord of the age of the my lord, the victim girl. So, if I my lord, go through the my lord, evidence of my lord, PW1, my lord, whether my lord, the case is probable or not, my lord.
Your statement, you have that's some of the evidence of some of the witnesses, I think.
My lord, mainly PW1, lordship will kindly go through the my lord, the cross-examination part, my lord. Elsewhere it has come, my lord. He is the mother, my lord. If your, as your lordship got the cross-examination part, my lord. In our house, we have 4 members consisting of me, my husband, and our 2 children. There is a road on the west side of our house. In the adjacent west side, these are, my lord, that neighboring people, my lord. Then, my lord, the next para, my lord, there are 5 family members of the accused consisting of his wife, son, daughter-in-law, and grandson. On the day of incident, there was a Shiv Puja in the house of the accused. When my daughter went to the house of the accused at that time, I was present in my house. I did not accompany my daughter to the house of the accused. The inside of the house of the accused is not visible from my house. I have not seen my daughter entering inside the house of the accused. I cannot say whether at the time of the alleged occurrence the family members of the accused persons were present at the house or not. Then, my lord, this These are some of the person, my lord, who were examined, my lord. After the occurrence, initially Jagdish Chaudhary, Damayanti Chaudhary, Abhi Pathak so and so came to our house and we discussed the matter with them. Then we called the accused, his son, his wife's son and daughter-in-law to our house through telephone and informed the matter to them. So, my lord, this affair was lost on the next day. And, my lord, this accused appellant was called to their house, my lord, and he was there till, my lord, early morning, my lord. And from there, my lord, someone has informed and he was apprehended from the house.
The Lordship comes to page 56. The accused, 56 Lordship, of the appeal memo Lordship. In the judgment itself, Lordship, Lordship will find that the accused, he in his 313th statement admitted that he was present at that time, Lordship, here in his house. And it has been observed by the court below also, Lordship, that that he was present there, Lordship. At 2:30 p.m., the informant and other villagers called him along with his family members to the house of the informant. The presence of the accused person at the alleged place of occurrence is admitted. Moreover, Lordship, the
Place of occurrence is his own house or what?
accused house. Yes, he was present there.
Appellant's house.
Yes.
Yes.
Moreover, Lordship, the statement of the victim also, Lordship, at page 57, that has been taken into consideration, Lordship. In the instant case, the victim is a 6-year-old child, and she has deposed that about 6 months ago, one day the accused, Ata, called her to his house, and then she went to him to the house. He took her inside the room of his house, and so and so. Thereafter, her mother was calling her name, and thereafter, the accused released her. Then, Lordship, learned court, while recording the evidence of the victim, has opined that he had the capacity of understanding and accordingly he was examined. She has narrated the whole story against the accused. He called the accused as Atta, grandfather. The evidence of the victim is found cogent, trustworthy and believable. Because, Lordship, such a young child, Lordship, he has no reason to frame him or have any sort of enmity with him, Lordship, so as to frame him, Lordship. So that has been taken into consideration, and other evidences also, Lordship, corroborate this finding. And moreover, Lordship, he in his denial, Lordship, he has simply denied. He has not adduced any other evidence, Lordship. Simple denial, Lordship. No, he has admitted. He has examined one witness on his behalf.
Defense
Lordship.
witness.
Yes. But, Lordship, that has also been taken into consideration. And Lordship will find that that observation is at Lordship. Yes, Lordship. It is in 56, Lordship, page 56.
Defense witness?
The evidence of D1, who is the friend of the accused, to the effect that some amount has been demanded from the accused, and for non-payment of demanded money, false case has been lodged against him, is not supported by any other evidence. That was the specific evidence of the DW1, which has not been corroborated. Apart from that, admittedly, DW1 is the school friend of the accused. They read in the same school, and as such, his evidence cannot be reliable. So that is also there, Lordship. In my humble submission, Lordship, this is not a fit case, Lordship.
But if we come to the evidence of the, my lord, defense witness, my lord. So, his evidence is that, my lord, he was there in the puja, my lord. For the puja purpose only he came there. And even the mother of the, my lord, the victim also, my lord, admitted that there was a Shiv puja in the house on that day, my lord. And, my lord, it is nowhere, my lord, in the cross-examination, it is nowhere stated that there was no puja, that you did not come there. Those things are not there, my lord. If we come to the, my lord, cross-examination of, my lord, the defense witness, my lord, may I just read it, my lord, that the daughter-in-law of the accused is not my daughter. No case has been filed because they have got some dispute regarding, my lord, their boundary line dispute, my lord. No case has been filed regarding the dispute between the accused and the complainant relating to the land. The distance between the house of the accused and my house is about 4-5 kilometers. The accused is my childhood friend. We read in same school. It is not a fact that the accused did not perform puja in his house on 17/8/2021. But my lord, the mother has admitted that there was a puja in the house, my lord. I cannot say the name of the villagers present in the house of the accused on 17/8/21. The name of the daughter of the complainant is so and so. Her age is about 4-5 years. I used to visit to the house of the accused on occasions. It is not a fact that the accused committed bad act on the victim girl of the complainant. It is not a fact that as the daughter-in-law of the accused is my daughter and the accused is my good friend, hence I have deposed false evidence in favor of the accused. It is not a fact that there was no dispute of land between the accused and the complainant. So, my lord, considering the evidence of the, my lord, PW1 and the defense witness, admittedly, my lord, there was a puja in the house of the accused appellate on that. And, my lord, immediately, my lord, that affair was not closed. He was called to the house, my lord. Then, my lord, from his house, from the IO's evidence, we find, my lord, that he was picked up from the house of the, my lord, the victim's house, my lord, at about early morning on the, my lord, 18th. PW5 has stated, my lord. So considering all that and, my lord, the almost, my lord, 2 years and 1 month, almost is going to be, my lord, half of the punishment, my lord. So I am praying, my lord, lordship, he is aged about, my lord, 65 years of age, my lord. Considering all that, my lord, I am praying before your lordship that he may be released on bail. And, my lord, the final outcome will come in the, my lord, criminal appeal, my lord, during the hearing, my lord. This is my humble submission before your lordship.
Lordship, only paragraph 28 of the judgment, Lordship, regarding the yes, the judgment. From the scrutiny of evidence and materials on record, it is established that the prosecution has succeeded in establishing the foundation of fact that the accused has taken the victim to his house and committed aggravated sexual assault on her by inserting so, and as such, it was the reverse burden of accused to disprove the same. However, he has failed to do so. The only witness that he had produced was the PW1. Has nothing to do with the statement, Lordship. His statement has already been disputed, Lordship. That there was a dispute and something like that, but nothing has been proved, Lordship. That's all.
Lordship, can we look at the evidence of the PW5 also, my lord, Damayanti Chaudhary, Jagdish Chaudhary, my lord. Yes, my lord, PW5, my lord. Cross, my lord. In the middle, my lord, the accused came to our village recently. The relationship between the accused and villagers is not cordial. I have no relation with the accused. On the date of occurrence, I came to my house at about 2:30 p.m. I did not see who was present at the time of LS occurrence. I did not see whether the victim went to the house of the accused or not. I did not see where from the victim came. The accused was confined in the house of Purnima Roy. On the date of the alleged occurrence at about 3:30 p.m., I came to the doctor's chambers along with Purnima Roy and the victim, but the doctor refused to examine her and advised us to go to police station along with victim, but Purnima Roy did not go to the police station along with the victim. Then we came to the civil hospital Bongaigaon, but the doctor of civil hospital advised us to go to the police station. Then we returned to our house. During this period, the accused was confined in the house of Purnima Roy. She is PW1, my lord, mother of the victim. In the meeting, there was discussion that the accused had to provide financial assistance to the victim if he suffers. Then the son of the accused expressed that they did not agree to pay any financial assistance. As the accused did not agree with the proposal, the matter was informed to the policeman. My lord, Lordship will kindly consider this evidence along with, my lord, his detention about 2 years and 1 month, my lord. So I am considering, my lord, that final hearing will be there and almost half the punishment he is there in the custody. So I pray that, my lord, he may be released on bail. I am obliged, Lordship. My lord. My lord, my lord.
Is the Lordship? Lordship, as per office note dated 28 to 2024, Lordship, the service upon the sole respondent has already been served, Lordship.
Oh.
Yes. So, Lordship,
As per
kindly.
office note 28 to.
Yes, Lord. So, kindly matter may be fixed for
How many private respondents are there? Only one?
Yes, Lord. Yes. Yes, Lord. Thank you. Yes. Not the
My Lordship, I will retract it. Lordship, can you fix a date for admission? If possible, next week.
It will become until June only. Next week is not possible.
Then may kindly fix date.
36 weeks or if want any earlier.
13/6. Any first week of June? 11/6. Much obliged.
May please your Lord. This appeal has been filed against the judgment and conviction passed by the Lani Special Judge Velasipara, convicting the appellant under section 4 of the...
Now you have appeared.
Lordship, I am appearing for the informant. I am the amicus appointed in this matter. What has happened is I have received this thing, my lord, yesterday, my lord. My lord, for a paper book. I have not received the paper book as yet. And the problem is, my lord, certain parts of the thing are in Bengali, man. The paper book will be required because there is no numbering, nothing done. Certain documents. So, my lord, may fix a date, maybe, my lord, for mail.
My lord, in this appeal, my lord, appellant was convicted for 7 years, my lord, under section 4 of the POSCO Act, and his 5 years already has over, my lord, jail period. So he may be allowed to release on bail.
My lord, at this stage, my lord, I've just
already
received
5
it
years
yesterday,
already
my lord.
allowed.
My lord, will allow me to, my lord, on merits may be heard, my lord. Some day may be fixed, my lord. Because in the meantime, I can get my, because I have not got the copy properly, my lord. And plus, it's in Bengali, my lord. Certain parts. So that part, my lord, be translated, my lord. My lord. That is the issue. And it's not numbered, my lord, so it will be difficult to, my lord. And the IA copy, though we haven't got as yet. But the IA which has been filed today, I've just got the copy of the main criminal appeal. So the IA is not before, has not been served upon me. That also is an issue. The IA, he's today, I think the IA has come. The IA is also not being served upon. IA copy, yeah. My lord, we fix it on some other date, my lord. On merits, we will, my lord.
Appeal may be hard, my lord. During pendency of the appeal, he may be allowed to release on bail. But already 5 years.
There is an observation most of the most of punished because he have received it. But now he is facing some sort of problem because some recording is not to be in Bengali.
The 164 also is in Bengali.
Yeah, he that for because portion which is Bengali. Prepare the paper for the that extent. That's fine. So you are finding difficulties basically on the evidences part.
Yes, no, that part and the recording. So that part may be wherever the translations are there. That may be they may be directed. So that they may be able to assist you. And plus the IA copy, my lord, may be served upon me. That IA which has been, he may serve it.
Those evidences of the period of this particular to make it paper so that so it should be listed up
TV. And in the meantime, and I'll take the IA copy also from here today. Deeply obliged. Deeply obliged.
As per lawsuit's order, there is 19 lawsuits we have impressed the forest department, and notice has also been served to the forest department. So basically, yes, sir. Forest department also probably the government is the necessary party because the forest is doing nothing. The case is now investigating by the police.
Mr. Botapur here.
Their name has not been shown, Lordship, but we have Lordship served a copy.
Yes, my lord. Earlier direction dated 19/4/24, petitioner to impeach forest as respondent.
Office note, Lordship may see office note 24/4.
Already.
Yes. And notice has also been served to them, Lordship, and we have submitted the Lordship servicing copy to the registry, and it is reflected in the Lordship system.
But my lord, in the cause list, name of first
Yeah,
counsel
name
is not shown in the copy.
That,
Yes, that needs to be reflected.
Lordship, their name may be reflected in the meantime. Lordship may call for the city also because it will be necessary. And the things Lordship is question in this application is regarding Lordship the Jimma of some goods. So these are Lordship no perishable materials, Lordship. These are lying Lordship in the police station. That may be called for. Now to know Lordship the status of those goods. These are lying Lordship in the report of the police station. Also.
record
Diary, because since it has not been felt, it will be case diary. Basic grounds Lordship has already had. Lordship basic grounds is that whether Lordship the magistrate has power to record his own order. Status reports of the Lordship seized materials. Next week, Lordship. 2 weeks, Lordship, if Lordship, as far as possible, Lordship fixed for the 10 days or one. Only the thing is that Lordship
12/6,
12/6 Lordship will be so long because Lordship the Lordship knows the goods are Lordship lying outside the police station. And the monsoon has started.
3 or 4/6. 4/6.
4/6. 4/6 Lordship. Oblige Lordship.
My lady, I just want to mention one item number 56 and 57. Several times it has come for consideration of bail. Appeal has been admitted. May I pray, my lord, it may be taken up on Friday. Friday?
Friday, though I cannot say. Friday, how many can it be?
There is a bail matter, my lord, 5 days, I think, to my, it has not reached.
It is completely supplementary.
Yeah, I should have mentioned in it early.
Again, Friday it will come again on supplementary list.
So let it be on Monday.
Monday or maybe Monday or Tuesday.
Yes.
In case it may come in the
Admission
not in the
column?
supplementary list, but in the regular
Main list.
main list. So supplementary may not reach out.
I will take the liberty to mention it for upgrading. 5-6 days, my lord, whatever the fate may be.
6 and 7.
Yeah.
6 and 7. Tuesday or Monday. Monday. Tuesday.
Lordship, I mentioned item number 50, Lordship. This is a bail application, Lordship. So my prayer is that it may be listed, if possible, tomorrow, Lordship. Not tomorrow, then day after tomorrow.
I'll not be here.
Day after tomorrow, Lordship.
Day after tomorrow it is already there. If it will not reach, that's why just I have just gone. Because
Okay,
if
my
it's
problem is
on
that-
Friday also,
Yes.
then in that case it will come under supplementary list. So it may not. That's what I.
Lordship, my
Take it
problem
on
is that
Monday,
one
Tuesday or Wednesday.
woman and the child is behind the bar.
Whatever,
Lordship.
Monday, Wednesday, or Tuesday. Either maybe Tuesday or Wednesday you can take.
Friday
Because it
supply,
will not come.
Friday
It will not
supply, well,
Friday
Friday
21 5.
Masha.
Lordship, with regard to item number 58, 59 and 60, Lordship, one of the petitioner is present, Lordship. Mr. Jayal Kamar was the petitioner. Is a petitioner.
58, 59.
60, Lordship. The whole pending matter, stay is also there, Lordship. So we file a petition for vacating.
We are ready, my lord, if you want to argue.
No.
No,
Not
I'm
now.
not ready.
Time is already over.
But he is so interested.
I am interested because the
Yes,
all pending
he's
matter.
interested.
I am interested. Not
I'm
only
also
this-
interested,
Not
my
only
lord,
this,
because
all
good
pending matter
bench
I am interested.
will do it.
Because
May I pray
13,
for
15
Lordship?
matters.
Yes, yes, Lordship. May I pray for Lordship?
So why it is in hearing column, na?
Hearing
Oh, acha.
It's hearing matter. It will take some time, my lord.
Can it be
On 24th, Lordship. Can it be on 24th?
24th and we want to hear this matter? So
Yes.
It will take time, my lord, your lordship, because there are so many fine points are involved. Because here, before the FIR was lodged, the money was all repaid to the bank, my lord. So whether in that event any case will lie or not, those are the issues. Plus Section 91 petition as wrongly disposed of. So we have to make all those points.
24th we may pick 24th.
24th of May.
Fine. Friday.
Friday. On 23rd is a holiday, Lordship. 23rd is holiday. 23rd is Thursday.
24 I am not in the town also. So we are going on.
Let it be on Lordship 30th of May.
30th of May.
Could do.
Lordship, can it be a fast track, my lord? It will
He is
take
also appearing for one of the cases.
2 cases, my lord. It will take long hearing, my lord. So many judgments are there, my lord. That's why I insist upon, my lord, Lordship fix the matter any day, fast track, my lord. Fast
Then
track
let
on
it be on
6th.
4th,
my lord.
It's a
I have no issue, my lord.
Tuesday,
Any day I am ready, my lord.
Tuesday, Lordship. Hearing day, Lordship.
4th is a Tuesday.
It is 6th, 4th, my lord. Other case is preoccupied, my lord. Can it be on 6th, my lord? It
Lordship, I
is
am
the
occupied, Lordship.
6th is the
It will
Thursday.
be on 4th only. Hear the matter.
We'll
It is the old pending matter.
In case of my lord, anything, my lord, Lordship, kindly accommodate me more.
I have got no issue, my lord. Let it be on the phone.
If I suppose I get engaged in some other court, my
We will hear the other petitions by
Yes,
the time.
Court will
Because,
proceed.
I,
no?
I think that these three may continue for not. It may
Lots
not
of
be
time.
one
Yes,
hearing.
yes.
It may take 2
Yes,
days
yes.
continuously.
Yes.
So in that case, if it is fixed on 4th, your matter may be heard on
Yes,
Yes, so much.
because you see the list is obviously today was not the hearing day, but the one matters are there.
But the time and again, Lordship, the matter is listed, but it didn't reach Lordship because may I pray for
Better to fix it on hearing day only,
At
so
2
that
p-
it can
at 2 p.m. Lordship, so that we can at least start.
go to party. Yes,
What
at
about
2 p.m.
you will do? We are ready, I am ready.
Let it be
At 2 p.m.
Lord.
We'll fix it then.
Lord.
On hearing on 4th.
Subject to our accommodation, my lord, if time permits. Because we have to also, we don't know what type of cases will come up on the day.
Time may not be fixed, my lord. It will be difficult some again.
But other but do one thing, Mr. Hatta, if
Let him make a mention.
time is suppose not fixed, in the morning hours only if you
I'll
make
make a
submission,
Yes,
make
yes,
a
you
mention,
can make a mention.
maybe listed at 2 or that if as per convenience of the other council. So in that case, so we are not fixing any.
No, because
time.
other council may also say, my lord, that our matter is also urgent, let it to come up on second matter, on at 2 p.m. Then there may be some disparity, my lord.
But these things actually should be
So
given because
it
all
should
are
not be
pending
recorded,
ones.
my lord, for the court convenience, I am saying so, my lord,
Yes.
with all responsibility.
Then if
Because others will take a precedent. If his matter can be fixed at 2, why not our matters? That was also. No, these things will come. We don't want all those conflicting way to look into things.
But we try to.
Yeah, we'll try to
Matter on 4th,
Yes, yes,
all are
absolutely.
old pending matter.
Absolutely.
That is on 4th, it may continue
Yes.
5 or 6 days.
So let it come on the court, we'll pick up
Yes,
the
okay.
second.
During
We are curious to do it, my
During the pendency of
Or your lordship can do one thing. You can make it part third.
Expired.
Your lordship can make it part third. Right?
No, don't keep it on part third because nowadays.
No, if he is so apprehensive.
My lord, if it is part third, my lord, it will be taken up by any man.
If I make part third, suppose.
No, if he is so apprehensive, that is the only way out. Then it's fine, my lord. We should not talk
Otherwise,
so much.
no issue, my lord. If my learned friend is
we
so
can leave,
curious, my lord,
No, I have not started the hearing.
I know, my lord.
Because if we start the hearing,
Yes, my lord, to wash off his mind from that not taking up the matter, so I have ensured that. So he is also not agreeing to that, then no issue, my lord. Let fourth come, we'll do it, my lord. Otherwise, it will be only talking and talking, my lord. Let us wait for the fourth. Much.
May please your lord. Lordship, in respect to item 51.
Yes.
Can it be, my lord, in the next week, my lord?
Lordship, I am appearing for the respondent number 2 in this matter.
In 51?
Yes, Lordship. Lordship, we have received the copy of the petition. 2 weeks time may be given. We will file the opposition, affidavit in opposition in this matter.
My lord, my anxiety is, my lord has heard, my lord, on the earlier occasion also, my lord. My anxiety is, my lord, regarding the interim prayer, my lord. Because, my lord, if, my lord, interim prayer is not granted, my lord, then the petition, my lord, itself will become unsuccessful. The respondent have appeared, my lord. My lord may heard it, my lord may dispose it of, my lord.
So, we can let's just see, we can fix either 1 week later or after 10 days, a fixed day can be. Okay,
after 10 days, it will be fine.
After 10 days, it will be fine. Fix a date on after 10. 31. Okay, we'll hear.
Can it be on any other date other than 31? Either 29th, my lord, 29th. Can it be on 29th?
Let it be on 1.
Then
one on 1, my lord. On
1
first.
is a holiday, I think. Saturday, 2 is Sunday, 3rd.
Then on 3rd. Then on 3rd. On
3rd.
Oblige.
May I please, your lordship, in respect of item number 49, lordship.
49.
This is a quashing of child marriage, lordship.
49. Quashing of child marriage.
Informant is a lordship stranger, lordship.
We should not give indulgence of the child marriage. So, you want to watch it?
Informant is the already stranger, lordship. He is, as per office.
Informant is stranger?
Informant is stranger. He is neither a family member of the victim or neither the family member of the accused. As per office note dated 13/5.
No, whatever. He as a, most probably as a person from that society, he
as per postal tracking report, lordship, he received the notice, lordship, but as per office note dated 13.
Okay, we don't have any time to clear this one. So as per you, is already you have
notice,
appeared.
Lord.
No, Lordship, I am going to again, Lordship, pray for, can it be on 17, Lordship, item number 50, Lordship. Can it be on 17, Lordship? Minor child is there, Lordship.
No, 20. Yes,
item 49, lordship, next to it.
Record. Service report.
As per postal tracking report, service is completed.
After 1. It will be listed after 1.
1 week.
1 week.
Any date, lordship.
No date, after 1.
Okay.